Good morning. Welcome, Peter and Tessa. Today we continue the 2 weeks of public hearings on the priority areas of child protection and the criminal justice system. But before we start, could I ask Commissioner Hunter to do the welcome to country and acknowledgement, please?
Thanks, Chair. I acknowledge that we are on the lands of the Wurundjeri people today and pay my respects to ancestors, elders, all Aboriginal people here and honour those that come before us so we're able to have voice here today. May Bunja watch over us as we conduct Aboriginal business. Woman Shaker.
Thank you, Council.
Chair, my name is Tony McAvoy. I appear as Council assisting the Commission.
Commissioners, my name is Helen Tiplady and I appear on behalf of the state.
Thank you. Thank you. Welcome. Welcome, especially Peter and Tessa.
Thank you, Chair. Today it's proposed to call a number of witnesses from within the criminal justice area. The first 2 witnesses are Peter Hood and Tessa Theophorus. I'm hoping I've pronounced your surname correctly. Will be followed by Alan and Corey Thorpe, Sean Braybrook, Karen Williams and Nakia Fibrace, who will be examined by Ms Fitzgerald. And then this afternoon there will be evidence from a number of witnesses representing the Victorian Aboriginal Legal Service, and I will be taking those witnesses. Chair, I call Peter Hood and Tessa Theophorus. Chair, for the record, Mr Hood and Ms Theophorus are on video, AVL link. Can I just ask you first, Mr Hood, to say your full name?
Yeah, thanks, Tony. My name's Peter Douglas Hood. I'm a Kurnai man in Gippsland. I also have traditional ties to other parts of the country, or Victoria. I would also like to dedicate my evidence today to my grandparents, Clarence Atkinson, Evelyn Atkinson, Nee Hunter, Noel Hood, Beryl Hood, Nee Stevens, my mother, Margaret Atkinson, and my father, Terry Hood. Thank you.
And Mr Hood, the evidence you will give today will be the truth. Is that correct?
I'm sorry, I didn't get that, Tony.
You undertake to tell the truth in giving your evidence today?
Oh, yes, I do.
Thank you. And Ms Theophorus, could you please tell the Commission your full name?
Yes, it's Tessa Theophorus.
Thank you. And do you undertake to tell the Commission the truth in your evidence today?
Yes, I undertake to do so.
And I apologise for the mangling of your surname.
That's quite all right.
Theophorus is correct?
That's right, yes.
And together, both you and Mr Hood have prepared an outline of evidence.
Yes, we have.
And that outline of evidence is true and correct to the best of your knowledge, and you adopt it for the purpose of this commission?
Yes.
Is that the case for you as well, Mr Hood?
Yes, it is.
Firstly, I might ask you, Mr Hood, to tell the Commission a little bit about your role with Kurnai legal practice.
Thanks, Tony, and thanks, Commissioners. My role predominantly is basically the Director of Liaison. So Kurnai Legal represents a vast majority of Aboriginal people. So I between basically our clients and our solicitors here at Kerno Legal, and mainly with Tessa, because Tessa being the principal. So, and it's about providing cultural knowledge, traditional families, etc., to our lawyers when they're representing our clients in court or any other parts of the criminal justice system.
And you've been involved in Indigenous affairs in the Gippsland area since 1987?
That's correct, yes.
And you're presently a member of the First Assembly of Victoria?
That's correct.
You've had other roles as in the legal sector?
Yes, I worked with the Aboriginal Legal Service for quite a few years. I was the juvenile justice worker in Gippsland for quite a few years as well, which I now believe they call the youth justice worker. Managed youth hostels, and so yeah, my involvement in the justice area has been for a very long time.
You've also worked for the Victorian Aboriginal Childcare Agency?
That's correct, yes.
As a program manager, that's correct?
That's correct, yes. So Victorian Aboriginal Youth Crisis Support Centre.
Thank you. Turning now to you, Ms. Thea Harris. You are the Principal Solicitor at the Kerno Legal Practice?
Yes, that's right.
And can you just tell the Commission about the inception of that practice and your role leading up to the creation of the practice?
So Peter and I developed Kerno Legal Practice together, and we started it in 2008. My role has been as the principal solicitor since we started it in 2008, and we've worked closely together in our respective roles to make sure that in our representation of First Nations people, that the representation we offer is culturally appropriate representation. My role as the principal solicitor is as a lawyer, but also to work closely with Peter to make sure that the representation we provide is appropriate representation at all times.
Can you speak about what prompted you to establish the firm?
Well, we both had various roles working within Indigenous community, and I had previously worked at VALS, and we both felt that we wanted to move towards a model that we had an idea for, where we could offer clients a more involved and a more hands-on approach in terms of being able to provide more time to our clients, and where we'd be able to be more rooted in community. So it was looking at being able to develop simple things like being able to conference with our clients before court, being able to have less clients when we were actually at court so that we could spend more time with them developing the way we represented them, so that our clients could feel that they had more time with their lawyers and more time to develop their representation and the defence of their case.
And have you been able to do that?
Yes, we have. It's been really successful, and it's something that we're really proud of. So there's now, I work with a team, there's 3 other lawyers who work with us, and we have clients throughout Victoria, statewide, and we've been able to develop the model that we had the idea for when we first started, so that we're particularly rooted in the Gippsland area, where we have and have had clients for a long time now, but also throughout other parts of Victoria. We've found it's been really successful to be able to have that ongoing casework with our clients, where we can spend time with them, particularly before court, so that our clients feel that they have time with their lawyers to prepare their cases properly, rather than having to try and speak to a lawyer at court on the day, with a lawyer who might have up to 20 or 30 other clients on the day. And
in that model, I understand that there is an important role for Mr. Hood in terms of ensuring that the client feels comfortable working with the lawyers. Is that the case? Yes,
that's it's an absolutely critical role that he plays with me and with the other lawyers. So on a daily basis, we work together. It might be either with having Mr. Hood at court with us or available by phone, or having him actually in community with clients in terms of the networking that he does to help us get our clients to court. But sometimes it's in the role as a cultural knowledge holder. One example is if we have clients who elect to have their cases proceed to Koori Court, increasingly the cultural knowledge that needs to be provided to the Koori Court for a case to proceed in Koori Court, detailed cultural knowledge needs to be provided to the court in advance. And he plays a very important role in being able to work with the client and the lawyers to make sure that correct and detailed cultural knowledge is provided to the court in advance of those hearings.
Mr. Hood, is there anything that you'd like to add in relation to your role in delivering the legal service to Kurnai Legal's clients?
No, I think Tessa pretty much covered just about everything there. But it has been important for Kurnai Legal to be able to provide, particularly with the Koori Court structure now, and all the details in terms of where people are from, who their people are, who they're related to, all that sort of stuff. So yeah, she's pretty much hit it on the head there.
Okay, I want to ask now about the funding of your client's representation. Can you please explain the model, the business model, I suppose, that supports your practice?
Tessa, you could answer that one.
Well, quite simply, we rely on grants of legal aid funding for individual cases. So we don't receive funding through any other arms of government. Consequently, a lot of the matters that we take on are pro bono cases. So increasingly, legal aid funding has been reduced. So, for example, legal aid no longer funds driving matters, for example. So the majority of those matters will still, for First Nations people, we will still run those cases on a pro bono basis. But if we have clients who are eligible for legal aid funding, then we'll submit those grants of funding. But otherwise, we receive no other funding through other funding sources.
Are you able to make any estimate of what proportion of your time each week is taken in pro bono matters?
I would say up to 10 to 15% of our time will be spent on pro bono matters. For example, one of our lawyers this morning is assisting a young First Nations child who's been charged with fines with offences from being on a train. They're offences that don't attract legal aid funding, but he's a young child who doesn't have any ability to pay the fines. He doesn't have an income, so he's spending his morning making an application to the court to have those fines waived. So that's 1 out of 4 lawyers in our office who's spending their morning working on a pro bono basis today, and that's not unusual.
And your firm...
Counsel, can I just interrupt for a second? Tessa, I had thought that children, in all cases, whatever, were eligible for legal aid. Things have obviously changed. Can you just give me an update on that?
Yes, so generally children are if they're charged with a criminal offence, but this matter falls under the civil jurisdiction technically of the Children's Court because it's what's referred to as capings or a fine against a child. So there isn't legal aid funding available for a civil matter against a child. So we'll do these matters pro bono because for children, they can have an impact. They cause a great deal of stress to a family generally. This young child lives with his grandfather and they have very limited financial resources. So we're assisting in that way today.
Thank you.
Now, your practice covers most of Victoria, does it?
Yes, it does.
And are there particular courts that you appear in more often than not?
Well, obviously being physically located in Morwell, that's our local court. So we're physically in the Latrobe Valley Court, I think, every day. But for example, today we have a solicitor appearing online at the Warrnambool Magistrates Court doing a bail application. We have other lawyers appearing online, I think, at Melbourne Magistrates Court and Heidelberg Magistrates Court today. We have barristers briefed for our clients in other courts throughout Victoria as well.
And do you operate in respect of all types of matters in court?
Within the criminal jurisdictions of the courts, yes. So for in the Children's Court, the Magistrates Court, the County Court, and sometimes in the Supreme Court and the Court of Appeal.
Do you represent clients in relation to child protection matters?
No, we don't.
And do you represent clients in respect of domestic or family violence matters?
Yes, a big part of our practice relates to intervention order hearings, and they often run alongside criminal charges. And again, they're a big part of the pro bono practice that we run. So we'll find our clients are often facing intervention order hearings in addition to criminal charges, and they're something that we will assist our clients with on a pro bono basis regularly.
And in your outline of evidence, you've referred to a Court of Appeal matter in relation to bail for a child subject to a protection order. Is there anything further you wish to say about that matter?
Just that it was a very important bail decision, not just for the child in that case, but for children generally throughout Victoria. That bail decision is used on an almost daily basis by defence lawyers throughout the state now. It was the first time that a bail case had been brought to the Court of Appeal with respect to a child, and we're very proud of the result that we achieved for that young person, and it's certainly a case that we use and that other lawyers can now use, and it's changed the landscape of bail law for children. It's an important example of how, despite the changes in bail laws and the impact that it has had, particularly on First Nations people, taking tenacious steps like appealing bad bail decisions can result in changes to the law through cases like this.
That decision, although it's not referred to by name in your outline, is that decision HA and the Queen?
It is, yes.
And the citation for that is 2021 VSCA 64?
Yes, it is.
And so it's a decision that in which your firm acted for the child, and it's become a matter of precedent for other bail applicants to use?
Yes, it is. And in that case, the child was refused bail in the Children's Court twice by a magistrate, and then a bail application was brought to the Supreme Court and bail was refused by the judge of the Supreme Court, and then that decision was appealed to the Court of Appeal. And essentially what the court considered was, in a case where a child was not likely to receive a term of youth detention ultimately, that it was unjust to effectively detain a child as a way of containing them, that it was a human rights issue in terms of the state detaining children in that way. And so it became a really important decision, and it's one, as I say, that is often used now.
Thank you. I haven't. Sorry, I withdraw that. In that decision at paragraph 7, the court notes that the appellant's youth and severe cognitive impairment, his vulnerability in custody, and the probability that he would not receive a custodial sentence was so powerful as to entail the conclusion that such risk as he presents is not unacceptable. And so that, in a nutshell, sets out the matters that the Court of Appeal took into account. You would agree with that?
Yes, I do.
And as you say, that raised a human rights issue in relation to the detention of the child on bail refused.
Yes, that's right.
Thank you. There are certain aspects of your practice that are particularly tailored to the Aboriginal community. That's correct?
Yes.
And it involves being able to support clients in coming to court, in ensuring that warrants aren't issued for non-attendance and similar sorts of matters. How important is that sort of support for your clients?
Peter, do you want to answer that?
Yeah, look, I think it's, thanks, Tony, it's very, very important that in the environment today, I mean, people have really only, well, Aboriginal people in particular, have only really cottoned on that a fail to appear is now deemed as a criminal charge, so it's an extra charge. So in order for us to counter that is, Tessa will give me the heads up, days or even sometimes weeks beforehand that particular clients have court on this date. So we work towards making sure that we get the clients to the court. So if that means that I've got to jump in the car and on the morning and door knock to find particular clients, well, that's what I'll do. And we get them to court, and it's sort of the lawyers, or Tessa and her lawyers, will take over from there. So that's something that we do, and I think it's something that it's worked, and it was built in the model when we developed Kernai Legal.
And what are the sorts of factors that might affect a client's ability to know that they've got court on a particular day? Can you make some observations about that, Peter?
Yes. Look, it could be something as simple as that not all Aboriginal people have mobile phones. And if they do, a lot of probably mobile phones, they're not connected. So it's not as easy as sending a text message or making a phone call. We actually have to use our network, our cultural network to find these people. And again, it's about getting out in the field and door knocking until we do eventually find who we're looking for. And it's not about, come with me, you've got court. There's a conversation that's had, and if you don't get the court, these are the repercussions that could happen. And look, some cases I may not find one or two, and before you know it, they've been picked up and they're on remand, and so it makes our job twice as hard. And I do explain that to our clients as well. That it's, you need to come along with me, get to court, we'll get this thing overdone with. And then what this does is it's explained to the client that this makes it easier for the next fella. For it might be your brother, it might be your cousin, or that comes along, and so it creates a really it's a good flow on sort of a thing. So yeah.
So, is it correct? Do I understand your evidence correctly in that you say that people might know that they've got court, but decide that they think that they won't go and that it'll be okay, and until you give them the information, they don't know the consequences?
Yeah, well, basically, yeah. It's sort of some people, and it's a lot of Aboriginal people are nervous about going to courts because, you know, their civil liberties, their freedoms at stake in some cases. And, you know, they think in order to get a day or two extra freedom, but, you know, but once it's found, and I know that once we get them to court, and Tessa has that ability, and she's also, you know, trained and educated the other lawyers that, you know, look, everything's going to be all right. We're going to do our very best in order to keep you out of jail, basically. And, you know, 9 times out of 10, it works. But it can be sometimes where some of the clients are just uncontactable by phone or email or all these simple things that they just don't have the means to. So in order to counter that, yeah, well, we have to door knock. Well, I have to. And sometimes Tessa will also. She gets out there and it's nothing unheard of for her to drive 80 kilometres to Sale to pick up a client and bring her back to court. I've seen that done. It happened a few months ago.
Is it the case that many of your clients are homeless?
Yes, absolutely.
And would you say, is it the case that some have mental health issues?
You broke up then, Tony, sorry.
The question was, is it the case that some of your clients also have mental health issues?
That's correct also, yes.
Yeah.
Amongst other things, DNA issues, family issues, you know, there's a variety of things.
So do those things also affect their memory and knowledge of court dates and ability to keep track of their requirements to attend court?
Yes, absolutely. And it's it's a practice in the office that Tessa will also has, you know, any of the staff here know to try and reach out to our clients either a week or a day before, right up to the day before court. Say, you know, listen, you've got court now. There's various ways of communications there. It's communicate through family members, whether that be a Facebook message or a text message or, you know, phone calls, or even somebody on the street. I might go up the street and see where all the mob are hanging out and, you know, mention, have you seen so-and-so? Say, yep, well, he's here. We'll then chase that fellow up and, you know, get him down to court.
Thank you.
If I could just briefly add something to that. In the cases where we can't get our clients to court, what we do is, though, we will still fight a warrant at court, and we will argue against a warrant being issued, and we will ask the magistrate for time. We'll ask for a short adjournment and say to the magistrate, look, we've spoken to extended family today. Can we have a week? And we have confidence that we'll get the person to court within a week, which is something that you don't often see lawyers doing, but we have a fairly proven track record, and we find that magistrates know, because we do then come back in a week with our clients, they'll give us that latitude. I did that yesterday, argued against a warrant for a man who was on bail, who's been very unwell and in and out of hospital, but he doesn't have a phone and he's homeless, and we just couldn't find him yesterday. So I argued against a warrant even though he was on bail, and the magistrate's given me some time now to find him. And we find that, as Peter was saying before, the flow-on consequences of warrants and charges of failing to appear are, when that person is then ultimately arrested by the police, those charges and that bail record will be used against that person in a bail application. So the police will then say, well, this person has a very poor history of attending court, and they're at risk of failing to appear. Even if those failing to appears are from years previously, that bail record will then be used against that person in a bail application in the future.
And so you, because of your position as a private practice, you're able to perhaps do things that are more difficult for community legal services?
I think so, yes.
Fairly accurate, yes.
From your outline of evidence, you've included some information about providing suits for clients when needed for court. Is that correct?
Yes, we think that's really important, that people are well presented and that they feel good about how they look when they go to court. We know that it makes a difference in terms of how judges and magistrates view people when they're coming to court. So we've got a rolling clothing rack so that we can make sure our clients are well dressed when they go to court.
Or my cupboard gets raided occasionally, and I have to hand over shirts and shorts and shoes and all sorts of stuff. So yeah, but this is what we do. This is what we do.
I just want to ask you some questions about a COVID-19 related proceeding that you've referred to in your outline of evidence. Would either of you like to describe for the Commissioner that proceeding? It's from paragraph 36 to 41 of your outline.
I'm happy to speak briefly to the case.
Yes, please.
It involves a client of ours who the court had indicated it was during the COVID-19 pandemic when cases were being administratively adjourned, and the court had indicated in writing that this man's case would be adjourned. However, the magistrate issued a warrant after the police prosecutor sought a warrant in court that day. And then the police executed the warrant upon him. He was homeless at the time. They found him essentially sleeping on a park bench, and these were for very minor criminal charges as well. And so he was then brought to court and remanded into custody. Bail was initially refused in the magistrate's court, and we sought bail in the Supreme Court, which was ultimately successful. But it was just, we felt that at every turn he'd been just treated very unfairly by the system, and it was a very concrete example again of how the changes to the bail laws impact and have impacted so adversely upon First Nations people. He was in an exceptional circumstances position, even though the charges were relatively minor, and he ultimately did not receive a term of imprisonment for the charges. The impact that these law changes had upon him and upon him having his liberty taken away from him were extreme, and the steps that had to be taken legally to secure his freedom were extreme in terms of the Supreme Court bail application.
So, looking at the outline of evidence, the Supreme Court bail application was filed, but that the opposition by police to the grant of bail was not withdrawn until the matter was set for hearing, and the bail application was set for hearing in the Supreme Court?
Yes, that's right.
Can the commissioners understand from your observations a few moments ago that is largely a function of the bail laws? That's correct?
Yes.
The client was an Aboriginal man. Were there any aspects of that particular matter that were changed or dealt with differently because of his Aboriginality, do you think?
Well, we felt that there were. He was a vulnerable man. He was homeless at the time. And we felt that the police did act with extreme prejudice against him at every step, in terms of right back to the point where they initially sought the warrant at court during the COVID period, down to when they came upon him and executed the warrant upon him, all the way through to their opposition to bail up until the point that we were in the Supreme Court. At every step, there was extreme prejudice exercised against him at every point.
So it wasn't just the bail laws, there was an additional layer of opposition that you detected?
Yes. And that's not unusual in terms of the way we see our clients treated throughout the justice system.
When you say our clients, you mean Aboriginal people?
Yes.
Councillor, I've got a question on bail. It might be appropriate to ask it now or not.
Yes, please, Commissioner.
Yes, thank
if you
you.
could ask now.
Tessa and Peter, you've been in practice over the whole period pre the Coghlan reforms arising out of the Gargas-Koulis case and afterwards. Can you tell the Commission what, in your view, were the elements of the Coghlan reforms that have resulted in so much bail being denied and so many Aboriginal people not receiving bail?
I think for a number of our clients now, they almost automatically find themselves in this much higher category of exceptional circumstances. So people who, for example, are either already on bail or technically serving sentence, which can include, for example, being on a good behaviour bond for a charge that includes a bail offence and then committing another offence, which is a Schedule 2 offence, so it can include another bail offence, then they're automatically in the most serious bail category of exceptional circumstances. We find that our clients are already at that very high threshold, even though the offences themselves are relatively minor and we know are not going to necessarily attract a term of imprisonment. So for First Nations people who might already be at such a disadvantage in the justice system, to then have to overcome the most strenuous bail test that there is right from the start before you get to the unacceptable risk test, it makes your bail position automatically extremely difficult.
Thank you.
Following on from Commissioner Bell's questions, you've addressed the bail laws at paragraphs 70 to 76 of your outline, and in particular, I draw your attention to paragraph 75, in which you note that following the high-profile case of James Gargasaurus, it's your observation there was a lot of trepidation on the part of police about being the decision-maker that grants bail. So whilst the bail reforms affect decisions by magistrates, you also detect that there's a reluctance by police to exercise their discretion in terms of granting police bail?
Yes.
And does that particularly affect your Aboriginal clients?
We believe it does. Police have the power to grant bail at the police station, but you're relying upon their discretion essentially to grant bail. One example is last week we had a client, a First Nations woman, who was charged together with her partner. They were both arrested from their home. Her partner was non-Indigenous. They were both essentially arrested for drug offences from their home. Our client, the First Nations woman, had far fewer priors than her partner. Her partner was processed out of the police station hours before she was and was granted police station bail. She was held and not interviewed for a further 6 hours, and then police remanded her and brought her before the court the following day. And she was in a position of exceptional circumstances and the magistrate refused bail. And that's just one example of how, when you're relying upon police to exercise their discretion, in a case like this involving an Indigenous person and a non-Indigenous person, we see it time and time again where we see the First Nations person not having the police discretion being exercised in their favour.
And this absence of the exercise of discretion, that flows through to police opposition to bail in court, does it?
Yes. Yes, it does.
And so at paragraph 72, the observation is made that 20 years ago, most clients would have been bailed at the police station, or you could negotiate for them to be bailed. However, you have not had the police consent to bail for one of your clients at court for the last 5 or 6 years. Is that correct?
That's right.
So
That's
in
right.
every matter you've appeared in, the police have opposed bail.
Yes. Even when you look at it and on the face of it, you think, even when our clients aren't in exceptional circumstances or even compelling reasons, when they have a prima facie entitlement to bail, we go to court and we'll approach the prosecutor and say, will you consent to bail for this client? We've not had one case for a First Nations person where a police prosecutor will consent to bail. Every single application for bail that we run at court is opposed by police for our First Nations clients.
You've just added for your First Nations clients. Are you saying that because your clients are First Nations clients, that's your observation, or are you saying that in respect of non-First Nations clients, that you have had circumstances where police have consented to bail?
Yes, we have some non-Indigenous clients and there is a noticeable difference in the police approach to those clients.
And have you had occasions where they have consented to bail for non-Indigenous clients?
Yes, I can think of one case where that has happened.
Do you know whether that's because of a direction from above to the police in court and on the ground?
I'm not sure where that's come from. I'll often push back. So when our clients are being remanded, I'll often have a conversation with sergeants at the police station after hours and encourage them to consider bail from the police station. When I go to court, I'll often encourage police prosecutors to negotiate bail conditions. I'm just told, no, there's too much of a risk. It has to be a magistrate's decision. I'm not sure where the directive comes from, though.
Thank you.
Now, some of your outline of evidence refers to police behaviour and in particular the use of racial slurs and the overuse of tasers. There's a number of examples that have been given between paragraph 50 and 69. Could you just tell the Commission about example number 1, which starts at 52, paragraph 52?
Peter, do you want to talk to that example?
Yeah, I do. I wasn't actually present, but I did see the video footage of this young Aboriginal boy getting.
Mr. Hood, before you continue, I just remind you that we should, in your evidence, that if you could not refer to matters that would identify any of the parties involved, either the client or the police officers.
Yes, of course.
Grateful. Thank you.
Yes, thanks, Tony. I was there about there. Well, this young fellow. What can I say? You know, I do know this fellow very well, some boy, and I witnessed the video footage of him being chased over fences, etc., and then being tasered constantly. It was very confronting for me. Well, you know, people. I'm sure people hear this all the time. It was like it was in the movies. But yeah, then he after being tased for, you know, popping all those volts of electricity, he eventually his bowels gave way and you know had messed his trousers up and things like that. It was very confronting witnessing that sort of stuff. But and I don't know how I would have reacted had I been there and actually witnessed it in person and live. I mean, it's, it was very shocking, very shocking
Did
stuff.
the footage show how the police were reacting?
Well, doing the job, I guess. It was, that's... Well, I suppose when a police officer pulls out a taser, well, they believe that they're justified in doing that. And that's, yeah, look, I think it's a really grey area that needs to be, sorted because, for me, just from my end, not that I believe anybody should be tasered, but this particular matter, I just didn't think it was warranted. And then the way it was, just sort of continued, it sort of got beyond, but as I said, it was very confronting.
And the use of force continued long after this young man had effectively been disabled by the police and continued. They physically dragged him to the footpath and he was begging for help and they were effectively mocking him when he was waiting for medical assistance. The footage went for quite some time until an ambulance arrived. So it was really distressing footage to see.
So neither of you were present on the occasion, but you've seen the footage. Is that footage still in your possession?
Yes.
Is it something that could be provided to the Commission?
With the client's permission, the case is now concluded at court. It's a really brutal example of how tasers are used. I think one aspect of it is that our client was not presenting any physical danger to anybody, and at the point where the police jumped over the fence, they didn't warn him or say, give him any instructions and say, if you don't stop, we're going to taser you. You can actually hear one of the police officers saying, I'm going to taser him. And then that's exactly what he does repeatedly.
Can I ask, did he need medical attention because he'd been tasered? Is that why the ambulance was called? Thank you.
Yes, yes.
And did he have any, to your knowledge, injuries from the arrest?
From memory, he did have. He was effectively given a cursory once over at the hospital and then taken immediately to the police cells, and then the police sought his remand in custody. And they told a very different narrative about what had occurred, which is why we requested the body-worn camera footage. So the police presented the case as our client being physically threatening to the person at the house he was at, and then physically confronting police as a justification for the violence that they used against him. But when we saw the footage, that actually was not the case at all.
Is it possible for you to obtain the consent of your client, do you think, to release of that footage to the Commission? Is that something you're prepared to pursue?
Yes, of course. We'll certainly speak to him about that.
Yep, definitely. After it's explained to him and everything else, and what it's going to be viewed for, etc., I think he'll give consent.
And that sort of treatment that you've seen for some of your clients can be contrasted with treatment for non-Indigenous people by police, from your observation? I'm looking particularly at paragraph 57 and 58 of your outline.
Yes, it's again a really stark contrast. We did have a non-Indigenous client recently that we were watching body-worn camera footage for, where he was severely drug affected and passed out on the bonnet of a stolen car, and it was difficult for us to comprehend the difference in the way the police approached him. They very gently woke him up. They made sure he didn't hit his head. They carefully lifted him off the car. He then just was allowed to leave the scene from the car. He had, as we found out later, he'd had drugs in his pocket. The car was stolen. He wasn't arrested. He wasn't confronted by police at all. So it was a really stark contrast for us in terms of that inherent difference in the way police approach First Nations people. We see it in the body-worn camera footage. It gives us a real insight into those arrests and those initial contacts that our clients have with police.
And is there, clearly the inference is that the treatment is racially discriminatory. Is there any other reason why there might be such a difference that you can point to, or it solely comes down to Aboriginal people being treated differently by the police because they are Aboriginal?
There's no other explanation for the difference in treatment. It just occurs constantly and all the time. I know from speaking to other lawyers and talking about their experiences with their clients, it's really, they find it really confronting when we speak about the experiences our First Nations clients have with police. They find it really difficult to even comprehend the experiences that our First Nations clients have.
And can we take it from the number of examples that you've used and your evidence just now that it's not restricted to isolated officers, but much more broad spread than that?
Yes, we see it statewide. So when we were giving evidence earlier about the different courts and the different regions we appear in, to be clear, we're not talking about police in Morwell only. We're talking about a problem statewide in Victoria. It happens in Preston, it happens in Warrnambool, Shepparton, Bairnsdale. These are all examples throughout the state. It's not confined to a particular part of the state.
At paragraph 66 to 69, you talk about use of strip searches, particularly with Aboriginal children. Can you just tell the commissioners your experience in relation to that form of policing?
It came to our attention just from speaking to our clients who were First Nations children. When we were speaking to them in the cells, we realised that the police were routinely strip searching them. We then started making inquiries with other lawyers about other children and realised very quickly it was only Aboriginal children who were being routinely subjected to strip searches. And it's something that we as a practice tried to address immediately. We confronted the police about it. They denied the practice. We actually issued then subpoenas upon the police on behalf of 7 Aboriginal children who we were representing after the police had denied that the practice had occurred. And we then obtained evidence that it had in fact occurred. And we understand that that was then a matter which was taken up through the Rajak and then the Justice Forum, and it ultimately resulted in a change in policy statewide through Victoria Police. So it's something that we're proud of, the fact that we were able to affect that change, but it's really concerning, and it's another example of how insidious racism is within Victoria Police and how these practices are allowed to develop, and if they're not confronted in this kind of way, they can just continue, and children can be subjected to this. It's effectively state-sanctioned violence if they're not confronted in terms of the practice. And it as I say, when we looked into it, it was only Aboriginal children that were being routinely subjected to these strip searches.
I'll just ask you a question arising from those observations. Are you aware of your clients making complaints about police conduct?
Sometimes they do. We encourage our clients to, we do refer them to civil lawyers if we believe that they have a claim that should be pursued. And that's something that we, as I say, we do encourage our clients to pursue that.
Do you have any view about whether there needs to be any independent police oversight in Victoria?
Peter?
Yeah, absolutely. I do. Yes, of course. It's like in any what do they do, investigation or anything else. I mean, you can't have, logically have an organisation investigating itself, because there's conflicts coming out left, right, and centre there. So, I think that's the way to go if you're talking about having, particular incidents investigated or any complaints dealt with, which is very, and it can be very difficult talking to Aboriginal communities in terms of the complaint process, because some of them just think it's too hard. There's too much. I don't want to go to court again. If I have to go to court again, I don't want to do this. Let's just forget about it. We'll just move on. And sometimes this can be the attitude, and and it's all based around fear.
Is it your observation, Mr. Hood, that Aboriginal people or your clients have any confidence that their complaints will be dealt with satisfactorily under the present complete police complaints system?
Yeah, no, they don't.
Does that deter them?
There's no confidence whatsoever.
Does that deter them from making complaints?
Absolutely. So some say, what's from conversations that I've had over the many years, what's the point? What is the point? They're just going to do this, or they're going to do this. This continues to happen. So it's something, again, it's that grey area that we really need to get in there and address.
I just want to take you back to some observations that you've made, particularly Mr. Hood, in relation to juries in Victoria and the juries that your Aboriginal clients appear before. You've made some observations in the outline. Could you just talk about that a little bit, please?
Okay, well, some of the matters, and look, and I've seen multiple matters where juries have been involved, and it's occurred to me over the years that the jury setup is based on the person accused being being judged by his peers. Now, you know, from all I could say confidently that, you know, any of the people on a jury that I've witnessed, that I've seen that an accused is an Aboriginal person being accused, sitting in front, they actually aren't his peers. He has really no, anything to say it, no social involvement with these sorts of people or anything like that. They're in a completely different world as far as I'm concerned. And again, I to this day, I still have not seen an Aboriginal person sit on a jury. So you know, these are fairly obvious observations I've made over the years, and I think Tessa can say the same as well. And she's probably seen twice as many as I've seen.
And that's your observation as well, Mr. Harris?
Yes, it is. It's a real concern. We often get concerned when we have Indigenous clients and we know they'll be facing a jury and the jury's going to decide on their guilt or innocence, and we know there's not going to be one other Indigenous person on that jury. And we know that those juries are going to be made up of people that you have to accept will be made up of people who will have inherent prejudices and all the problems that go along with that. To not have anyone else from your client's community on that jury, it's a real problem. It's something that we are always concerned about when our clients are facing jury trials.
So in your outline of evidence, you've identified that one of the issues is that the juries are drawn from the electoral roll, and many Aboriginal people aren't on the electoral roll. Is another issue the requirements or the qualifications on eligibility set out in Schedule 1 of the Juries Act, limiting people in terms of their criminal histories?
Yes.
And so that disqualifies people if they've been before courts for various offences within, in some cases, the last 2 years. Would that have a great effect on the availability of Aboriginal people for jury duty, given the way in which policing is undertaken?
Yes, it's another thing that has an impact on having Aboriginal people available in jury pools. We also know just from speaking to community that many First Nations people feel that the white electoral process is disenfranchising to them, and so they don't choose to enrol in mainstream elections, which means they can't be selected for jury duty. And it's an area that we think government needs to seriously look at, the way in which jury pools are selected.
I'll just make a comment here. I was a judge of the Supreme Court for 15 years and did jury trials intentionally over that time, probably as many as 100, though I haven't counted them. Because there's 12 persons plus in a criminal jury and 6 persons in a civil jury, I've interacted with several hundred jurors over my judicial experience, and because of the way that juries are selected involves selection from pools, numbering, well, very many, 10, 20, 30, even more than that, depending on the nature of the trial. I've interacted with some thousands of people who've presented for selection on a jury. I would say that I've never seen a recognisably Aboriginal person in either a pool or selected for a jury. That doesn't mean that there's not an Aboriginal person in that number, but not recognisably. And I've never seen somebody declare their Aboriginality, though I wouldn't expect it. A concerning thing is that a large amount of the work that I've done in this capacity is in regional Victoria, where a very large number of Aboriginal people live, particularly in certain towns, including in Gippsland. And I make the same observation with respect to my experience in those places.
Thank you, Commissioner Bell. I notice, Mr. Hood, that you're nodding your head. Can we take it that you agree that Commissioner Bell's observations accord with your own?
Yes, Tony, that's correct. And look, and my evidence today is that because I haven't personally seen or viewed any Aboriginal people on the jury, doesn't mean that there hasn't been. And as Commissioner Bell has pointed out, there could have been, but it can be really, it's frustrating. But over the years, it's been frustrating, particularly with the jury pool setup. But I agree with what Commissioner Bell is saying. So yes, I do.
Can I ask you this? If there was an Aboriginal person on a jury panel, it's more likely than not that you would know them or their family, though, isn't it?
In Gippsland, most likely, yeah, in Gippsland, maybe Melbourne, which again, what a letter of the law can cause all sorts of complications, but it's they'd most likely get expelled. But it's very possible that and our Aboriginal communities are people know this one related to this one related to that one. So it's and Aboriginal community is ultimately small, and as I said, people know people, but it's an observation that I think really needs a really good hard look at in terms of people's, particularly Aboriginal people's involvements in the jury system.
Council, just because we're having this conversation, I just want to share that I have been called up for duty service in regional Victoria and was knocked out by a defendant just by his looking at me as I got close to him. So I just want to put that on the record.
Yeah, that's right.
Thank you, Chair.
He might have missed out on a good juror.
Whatever that
I
means.
want to now just briefly take you to your outline of evidence where it deals with the role of Koori courts. And is it fair to say that your experience with Koori courts has been positive?
Yes, I agree. Yeah, the Koori courts, but like all whether it be courts or other systems, there's always room for improvement. And I think that'll evidently that'll go in time.
And Ms. Theoharis, you were nodding your head in agreement with that proposition that it's a generally positive experience with Koori courts?
Yes, we've had a number of clients who've had really positive experiences in Koori court. We'd like to see the model of Koori court available through all courts though, and I think something that our clients often say is, why do I have to plead guilty to be in a Koori court? And we think there's no reason why the model of Koori court can't be available through other courts. So having elders available to provide cultural knowledge to magistrates and judges, and having a more culturally appropriate courtroom is a model that there's no reason why that model couldn't be available for a bail application hearing or even for a trial, as we've just been talking about. We would really welcome the opportunity for the model to be used in other court sittings other than plea hearings.
Is the Koori court available where a person has pleaded not guilty but ultimately been found guilty after trial?
Technically, that should be the case, but I think that is rarely available. So generally, a judge who has found a person guilty, or a jury who has found a person guilty, then the sentencing falls to the judge who's presided over that trial. Although I understand the legislation does provide for sentencing to occur in the Koori court. I don't believe that generally happens.
And is it your observation that having matters heard in the Koori court is more meaningful to your clients than perhaps in the mainstream court with an all-white jury?
Yes, and I always say to my clients, in mainstream court, you'll just be sitting behind me and I'll be trying to tell your story for you. But in Koori court, you can tell your story in your own words for yourself. And I always say it's a good Koori court if me as the lawyer doesn't say very much. So it's the one court where our clients have a real voice and where our clients' family and community have a voice. So it turns the mainstream court model on its head. And that's something that we try to teach the other lawyers at our firm about as well, is it's okay as the lawyer to not speak. And it's quite funny sometimes to see lawyers from other practices struggle with that when they're appearing in Koori court. But it is definitely the hallmark of a good Koori court sitting where the lawyer doesn't speak, but where your client has the voice.
And that answer, I think, feeds in neatly to your observations regarding the importance of cultural knowledge for both practitioners and judicial officers dealing with Aboriginal people. Is it your observation that much greater work needs to be done in terms of cultural knowledge in the legal profession?
Yes, definitely. I had a magistrate last week who ultimately bailed my client, but said to him in granting him bail, you better comply with your bail conditions because next time you won't be able to play the Indigenous card. Mm-hmm. They were a magistrate's exact words to our client, which are words that should never be said in a courtroom. That magistrate obviously needs some training, I think. Or recently I had to seek an adjournment for a client because it was his uncle's funeral the following day. And the magistrate was questioning my client's relationship I had to provide the funeral notice. I was questioned about the family connection. The magistrate questioned that family connection. I had to explain to the magistrate that I was prepared to give evidence having personally known my client and his uncle. Then the magistrate asked me about the location of the funeral and wanted to know what Kamragunja was. Again, an example of a magistrate who needs some cultural training. So we've still got a long way to go when we're still having to, as lawyers even, fight these fights in a court on a daily basis for simple things like this.
Thank you. I just want to take you back now to the issue of your involvement with the young Indigenous Aboriginal girl that passed away on shoplifting charges. Are you able to speak to that, Mr. Hood?
Yes, Tony, certainly. It was a very, very, I believe it was a very avoidable tragic event. It could have been avoided. It was very sad how that all panned out, and it takes me back to my very first sitting as an Assembly member of the First People's Assembly, Parliament House, and actually had the Premier and the then Minister for Aboriginal Affairs come in and meet with us, and I asked them a few questions about the current bail laws and how the system would work, and they actually said they'd get back to me. And my point about the question was about how the bail laws were working against Aboriginal people. Now, it was probably just over 3, maybe 4 weeks later, probably 3 weeks. Me we had a young Indigenous girl die away in custody, pass away in custody from being remanded on a shoplifting charge, and very, very sad, and it's my testimony that could have been avoided had things been in place, or the system that does exist. I don't think it worked very well that day. Yeah, so very sad.
Thank you. Commissioners, they're the questions that I have for these witnesses.
Yeah, that it's on. You may have answered it, but I just wanted to flesh it out a little bit. And I think, Tessa, you brought up that you encourage the clients to follow up or pursue any police complaints. And then I think, Peter, you also said that, people have had enough and they just want to get on, and it's more court sort of stuff for them. So it's how would you be able to just roughly off the top of your head, what is the percentage of people that you ask to actually follow them up of your First Nations clients?
Wow, it's be very little. I'd imagine it. If I had to say out of every 10, it would be maybe 1, maybe 2, and and then you sort of sit and wait to hear how that process is going, and they may get to a certain point and then just, as I said before, put their hands up and say, no, it's all too much, let's just walk away. Because remember, it's explained that the rule, and I would explain to the client who wants to put the complaint in, there will be opposition. It's not just this straight cut and dry process where you put the complaint in and it's dealt with and everything else. There will be opposition, you will be questioned, sort of thing. And people just don't want to go through that sort of stuff. Even though, evidence is clearly there that they've been violated or, that in that aspect, but they just don't want to go through that. So, yeah.
Thank you. And just one other thing, and Tessa, you mentioned about pleading guilty in the Koori courts, that you had to plead guilty to use them. How many of your, or roughly, would a lot of your clients plead guilty to go to the Koori court, or they would just go through mainstream? Like, it's as you put in your statement, which is a barrier. So I'm wondering sort of where that sits for your client base of First Nations people.
We really encourage our clients to first try and negotiate their case, and then if it does settle it, then we can consider the plea in Koori court. So rather than saying we'll just go to Koori court at the start and plead guilty even though you have a defence. So it's part of a process. But yeah, we definitely don't encourage our clients to plead guilty when they have a defence, or we explain to them that they can't have their case heard in that way if they want to challenge the charges. But certainly if we go through a process, for example, we go through a contest mention and a number of charges are withdrawn, then at that point we'll book their case in for Koori court if they want to, with the charges that are left.
Right, and one last one. Do you know any model similar to yours that operates a similar legal model that goes above and beyond, I think, really, as you've explained, and you know the amazing work you do of making sure people do appear, they're dressed properly. Is there any model of another legal service that you know of that does similar work to yourself?
Not that I'm aware of, no.
Thank you.
Tessa?
No, not that I'm aware of.
No.
Thank you.
Thank you. We had a witness yesterday who stated that they believed that Victorian police feel that they can act with impunity towards First Nations peoples. Would you agree with their contention?
I think that's certainly a big problem, and that's borne out in the way they do act towards First Nations people.
Kevin?
Just following on from those questions, Ms. Theoharis, at paragraph 59 of your outline, you set out an example where a single Aboriginal mother reversed into another car at a car park and went to the police station to try and report it, but the report wasn't accepted, so she went home, and then that night 10 to 12 police officers turned up at her front door with a tow truck to impound her car, and Mr. Hood had to attend at the scene to try and assist. So in circumstances where that's the response from police to what would ordinarily be an innocuous report of a small incident in a supermarket car park, do you think that explains to some extent the lack of confidence or reluctance of your clients to make complaints about police?
I think it really does. And in that example, this woman called me and told me what happened. I advised her to go and report the accident. And then she called me and said they wouldn't take my complaint. And then a few hours later, I got the hysterical phone call. They weren't just there to tow her car, they were trying to break down her door to arrest her, and she was trying to negotiate through the door to explain she was a single mum and had young children in the house, including her 10-year-old son who was a severe epileptic, and she didn't want to be arrested and taken away for the night, leaving her children unattended. And that's why Mr. Hood ended up going there to try and speak to the police to diffuse the situation, because it had been escalated to such an unreasonable and outrageous level where the police were trying to break down the door to arrest this woman over essentially a fender bender in a supermarket car park. Her car did end up getting towed, and we ended up having to go to court to make an application to get her car out of an impound yard so that she could drive her children to school.
Thank you. Commissioners, are there any other questions for the witnesses?
I have no questions, but to thank both Tessa and Peter for such a...
Thank you, Commissioners, and I would tender the witness outline of Peter Hood and Tessa Theoharis, as well as that's document 7.1. Document 7.1.1, an article from The Age entitled Aboriginal Man Locked Up in COVID Court Bungle. 7.1.2 is an ABC News article entitled Vulnerable Indigenous Man Locked Up by Police in String of Errors During Coronavirus Pandemic. And 7.1.3, a 3CR radio interview with Tessa Theoharis entitled Aboriginal Deaths in Custody and Systemic Racism.
Thank you. Those documents will be allocated the next exhibit numbers.
And I confirm, Chair, that the Council assisting will ensure that contact is made with these witnesses in relation to availability of some of the video footage that's been referred to in the evidence, and that might be tendered at a later stage.
Thank you. Noted. Thank you.
Thank you.
That's the evidence from these witnesses, and if they might be excused. Thank you, Commissioner. The next witnesses are being taken by Ms. Fitzgerald. And we might adjourn for a few moments to set up for that panel.
Yes, thank you. Please. Thank you.
Commissioners, next we have a panel of witnesses who are all working with First Nations peoples who are caught up in the criminal justice system. They work for and run organisations that are providing First Nations-led solutions, healing and restorative justice and cultural connection. And those witnesses are Mr. Alan Thorpe, starting on the end there, Mr. Corey Thorpe, Arnie Williams, Mr. Firebrace, and on screen we have Mr. Braybrook. I'll swear everyone in first, and then I'll ask the panel members to introduce themselves. Mr. Braybrook is from I'm going to pronounce this Wollonganalu. Is that right, Mr. Braybrook?
Wollonganalu.
Okay.
Wollonganalu. Very good effort. Thank you,
Sean Braybrook, do you undertake to provide truthful evidence to the Yoorrook Justice Commission today?
I do.
Now, Karen Williams, Auntie Williams, from Victorian Aboriginal Community Services Association, which is known as VACSAL, specifically the Bert Williams Aboriginal Youth Services Program. Karen Williams, do you undertake to provide truthful evidence to the Yoorrook Justice Commission today?
Yes, I do.
Now, Alan Thorpe from Dardi Munwarrow. Alan Thorpe, do you undertake to provide truthful evidence to the Yoorrook Justice Commission today?
I do.
And Corey Thorpe, also from Dardi Munwarrow. Corey Thorpe, do you undertake to provide truthful evidence to the Yoorrook Justice Commission today?
I do.
And finally, Nakia Firebrace from the Victorian Aboriginal Childcare Agency. Will you raise the mulka and perhaps first explain to the commissioners what that is, and then I'll ask you to make the declaration.
With this, Commissioners, this is the Malka of Yoorrook. This has been handcarved by me with the blessings of our Tumalas, our senior members of my nation. This Malka has been held by children of care, children of country, and also community members that work with our people in the community. So with this on the basis of law and integrity, Ingue, yes.
You undertake to provide truthful evidence to the Yoorrook Justice Commission today?
Ingue, yes I do.
If we can go back to you, Mr. Braybrook, will you introduce yourself personally and professionally and explain the work that Wollonganalu does with men on community corrections orders?
Yeah, definitely. And thank you very much to the Council for giving me the opportunity to speak. I am an Aboriginal man. I was born on the Wurundjeri country and lived all my life on the Wurundjeri country. My grandfather's line, Aboriginal line, is from far north Queensland, which that is Cook and Yalanji as well. So, me personally, I've worked in this space for a lot of years, but didn't begin my life in this space. I'd like to share this as well. I started my life as an apprentice plumber, and I was a young Aboriginal boy that benefited from an Aboriginal employment program. So I'm very passionate about that very early start in life for people as well. So from there, my professional life then took a major change, and I ended up working with VACSAL for a little while as an Aboriginal youth support worker. And my whole idea around the Aboriginal Youth Support Unit working at the time is I couldn't believe, coming from a plumbing background, that people paid you to do this work. It was so enjoyable and great work with the community and doing great stuff. And really have really great fond memories of Bert Williams and working across that whole youth justice system and that whole diversion stuff. From there, I ended up working in Port Phillip Prison at the time. So I spent 5 years working at Port Phillip Prison. And I'd just like to note too that when I started working at Port Phillip Prison in the year 2000, 2001 actually, I was the only crew support worker working within the prison, or AWO at the time, and it was actually a private prison. We did have, and people would remember, Arnie Carmel Barry that worked in the system as well and was a great mentor at the time, and Uncle Reg Blow as well, across that time as well. But I was actually based in the prison, so I share that professionally as well. And then I actually left the prison and went and worked in Corrections Head Office for a while. So I spent a lot of years working in Corrections Head Office and implementing a lot of cultural programs across the prison system and that as well. And since 2006, I've been the General Manager of Wollonganalu Learning Place. So what is Wurrunganawulu? Let me share it with you. We're a key initiative from the Aboriginal Justice Agreement as a partnership with the Aboriginal community and the Department of Justice or the Victoria Government as a diversion program to see help men transition through the justice system. So our core business is to help Aboriginal men on community corrections order to complete their orders. In that sense, what we actually do is men come down here and live anywhere from 3 to 6 months, live on site. We do educational staff, program staff, and the whole focus is around culture. So our cultural identity, and I can talk a little bit about that more, about the actual work we do around our culture and our cultural identity. Have a real cultural overlay to the place, and we support the men through that journey, strengthening cultural identity. So one thing that we always say is the strength to Wurrunganawulu is, first of all, we support the man, we strengthen the cultural identity, and then we address the behaviour. So that's our sort of steps that we take in working with our men. The keys to us is it's a voluntary place. So even though we are working with men that come in contact with the system, every man at Wurrunganawulu chooses to be here. Yeah. Now there are some men that's in their best interest to be here, but they still choose to be here on that journey. So that's sort of in a bit of a nutshell, I suppose, about the work I do.
And you mentioned the cultural identity work that you'd like to touch on a little bit more. Can you explain practically what that work involves?
Yeah, well, the whole place, we like to think that we have the cultural overlay right within a cultural facility. Still being in the Department of Justice facility, and we're all Department of Justice employees here at Wurrunganawulu, so that's very important for us. So the first part was about the physical side itself. So we're actually based on the old Ron prison, which is down in Ron, if people don't know. So probably one of the lucky ones I've got on my resume that I bulldozed to prison. So not too many people will have that. But Aboriginal elders walked the site and got their inspiration, and with an Aboriginal architect, his name is Dylan Combermary, and that's where the place grew from that. So the place is built with the Aboriginal overlay of the blue wren, so the Indigenous birds of the area. So very important that the whole site, first of all, has a real cultural feel to it. We're a big property, 162 acres, mostly natural bush, and we occupy the front of it. So a very, very good layout for the place, and significant cultural sites around the place with an open space. Men have space to work and live. I'll just explain it quickly. Our main buildings are up the top, where our admin office is. We have a learning room. We don't call it a classroom, we call it a learning room. We have our common area in that as well. So there are 3 main buildings up the top. That's where we do our work. But then over night time, the men walk away to sleep. So they go down the hill and just over a little bit, and they sleep in their units, where 3 units are 6. So it's sort of like that transition. We come up, we do our stuff, do our cultural business, and they walk away. The heart of Wurrunganawulu, we have a fire pit, and that's where all our business gets done. It's really, I think I can explain it like that. That's where all our business gets done around it. It's a real place that you have to see when we talk about that cultural overlay. It's a real visual thing. So that's first of all for the place. The cultural strengthening we look at is we want men to come here and be challenged around their cultural identity. What does it mean to be an Aboriginal man in today's society? And that's a lot of the work that we do around that area. We teach dance. We have a set of Wurrunganawulu dances that we dance. So we did a lot of work with the Gunai Kurnai people as well, and looked at what we could do on their land and that sort of stuff, and got permission and that sort of stuff. So we create a lot of dances ourselves. But the real cultural strengthening comes is when men come down here and share their cultural knowledge. So we might have men that might not have a real strong cultural identity. Yeah, they'll come down, they're like big sponges and soak up everything we do around our cultural programs, our cultural overlay, our cultural dance and the other stuff we do. And then when men come down that may know dance, may know whatever they do know, give them that opportunity to share that is really important. And that's one of the parts that we say about passing on the knowledge and sharing that. So it really takes that cultural strengthening to another level in that. So when I say about strengthening one's cultural identity, then all the other stuff starts to fall in place. Men buy into the place, being a voluntary place, 3-hour drive from Melbourne, you know, and choosing to be here, choosing to stay on site. Once they start to buy into that cultural identity, that's why men will stay. That's why men will participate. Then the rest of the work you do, especially around our education and living skills that we put on site, and even our corrections order, the work that we need to do around the community corrections orders and that, all that gets accomplished and achieved in that as well. Because the men are achieving something and something that they want to achieve. Find out more about themselves and who they are and that cultural identity.
Thank you, Mr. Braybrook. One more question for you before I ask the other members to introduce themselves. You've worked extensively throughout your career within the mainstream criminal justice system and specifically the corrections system. Some of our witnesses have said that the system itself is racist. Do you feel that you've been able to make a difference from within that system? And what impact do you think having First Nations people working within that system can have?
Yeah, definitely. I've spent a lot of time across the system, as people know, especially that 5 years at Port Phillip Prison, being a private prison, really taught me a lot about the system and understanding the system. And I've chose to work inside the system and work from outside. So some of the things that have really made a difference that, you know, I've had a big hand in was some of the cultural programs that come into the prison now. The Malamari program was a big one. Transgender trauma, we took that into Port Phillip Prison, and it's really great for the fellas to be able to have these opportunities. So really focus on that. My big thing as I work across the prison system, and I hope to think that this still continues today, is my big focus is bringing the outside in. Now, if we can't take fellas out of the prison, let's bring the services in. No, and that can be a challenge, I know that, but that's what we always did. So my focus when I was working in the prison was looking for what we could bring inside to support the men inside, building up them relationships and that as well. So I think I definitely agree. People would look back and see a lot of the racism within the prison system, and I've seen that firsthand myself. I do believe there's lots of goodwill in the Department of Justice and through the correctional system, and especially at the top end where it all filters down. But then as it comes down to on the ground and the way it works, and I think that's the challenge, is keeping their messages going through to the place. And for me, it's all about having more Aboriginal people working in the system and making sure we support them Aboriginal people working in the system. You know, we need to do that. We need to ensure that.
Thank you, Mr. Braybrook. Ms. Williams, Auntie Williams, could you introduce yourself personally and professionally and explain the work? I think if we focus on Bert Williams, but if you'd like to speak more broadly about VACSEL, please do.
Okay, so I'm Karen Williams. I'm a Aboriginal Torres Strait Islander woman from Queensland. My people are the Bindal and Yoorrook, with my heritage from the Torres Strait Islands being Downley Island and Murray Island also. I moved to Melbourne from Queensland when I was 21 in 1985, and I came to study Aboriginal health. I had a real feeling I wanted to be a nurse, and I felt I could make a difference if I went into the health field for our people. And I did that course for 12 months, and I then got work after that in the Victorian Aboriginal Health Service from 1986, and I left VARS for a little bit of time and went into the youth justice out at Bert Williams Centre as a worker for a couple of years, and then I got coaxed back to the health field for 3 more years, and I'd really had enough. By that time of 3 years, I'd had enough, and I needed to go into the space where I felt like I could make a difference with young people. And working with young people before they turn 18, I really believe you can make changes. And so I started working as a Koori Youth Justice worker at Bert Williams Centre. And I must say, I learned a lot of my stuff from a lady by the name of Yvonne Luke, who I used to shadow around. So Yvonne worked within the department as a Koori Youth Justice worker, also with VACSEL. So I learned a lot of my stuff from Yvonne, and I needed to acknowledge that today also. So I've worked as a youth justice worker, and now I manage the service at Bert Williams. And in our Bert Williams stream, we have 3 different streams, which is the homeless hostel for young people. We also have the Koori Youth Justice Program and the Early School Leavers Program that sits within Bert Williams. And I would like to start with talking about the work I do for VACSEL and Bert Williams Centre. I really have a passion for young people and I'll fight really hard. So I'll start by like an example of when a young person comes into, so we get our referrals usually from the department or from the community. So we'll actually do an assessment of the young person within the first day or so. Make sure that we do a case management plan, work really hard on cultural support plans, and the cultural support plan comes from information from the young person. So one of the things that we really do is empower the young person to give us all the information for those cultures, because that's their document. And then we work from that. And we also work with the department because our referrals come from there. So we're doing a crossover with youth justice in the department and our community workers.
And Arnie, when you say the department in that context, is that the Department of Family, Fairness and Housing or Department of Justice?
Department of Justice and the Youth Justice crew, yeah.
Sorry, keep going.
I don't know, you might want to ask me something to prompt me because I'm a little bit,
yeah. So you were explaining the 3 different streams of work that Bert Williams does.
Yep.
And if you could step through those, and then there's an example I wanted to ask you about.
Okay. So with the homeless hostel, it is for young men between the age of 15 to 22, and they're homeless young men that have nowhere else to go out. And so we'll take in young people, but we also, at one stage, B-Ways was a place for young people coming out of the youth justice system. So being in Parkville or Malmesbury, we used to be able to take them in at one stage. That's changed just because of not a lot of supports are in place for our young people when they come out. So it's difficult to do it as one organisation, and there's a whole heap of things going on with the young person. So, and we'll manage in the hostel. We get them in, and we get them into some kind of program, so they'll go to school if they're not at school already, or we'll help them find a job, any kind of training, anything that keeps them busy during the day. So we really want them to be active and really put some effort into their future. So we talk to them about what they want for their future, what do they want us to do, how do they want us to do these things. So it is real stuff for them to contribute. And then we go and have a look at it again a couple of weeks down the track and see if things have changed for them as well. And that's the hostel. And they can stay with us for 6 weeks to 3 months. I would struggle with a young person leaving after 3 months when they got nowhere else to go. So I'm a little bit of a softie, and I'll keep them there for as long as I can, because there's nothing worse than having a young person on the streets homeless. And I've got real passion to keep caring for them and nurturing them through that process. And that's just part of what we do in our hostel. And then we have our Early School Leavers program, which is about keeping young people, and it came out of justice funding to keep a lot of young people who were having issues in the youth justice system weren't at school. They weren't in an education pathway. So the ESL program gave us some funding to engage with young people to keep them at school. So we get funding for 10 to 20-year-olds, and it also helps our young people who are looking for apprenticeships and stuff. So we kind of do a lot with them, and it's like we want kids to stay in school, so we provide right from the get-go uniforms, supports in classroom, to books, everything, and we get other organisations involved. So a lot of parents can't afford high school books and things today, so our ESL program will go out and source, and we're sourcing other funding all the time to ensure that our kids are at school and staying at school with everything that they need. And we even, like, the 20th Man is fantastic. A part of our partnership program we do with the 20th Man is they provide all of our children with high school books. So we actually sign up with them every year, and we do that work with them as a partner, and that's just something we've done forever with them as well. And then we've got our youth justice program, which is where the referrals come from community or the department. and it's a process. So the referral will come in, our guys will have a look, and we don't say to nobody, we don't say no to anybody. We actually try and take as many in as we can and do what we can the best. And that's also with an assessment and a case plan and continuous cultural services for our kids, because they're lost in the system. A lot of them are in trouble because they're actually trying to fit in community. They're getting in trouble because they want to fit when they don't know, and a lot of them will choose the wrong path if they don't know where they fit. And if we can get them to know where they culturally come from, connect them to community, it actually makes a difference. So our youth justice team are doing that constantly, because a lot of our kids in our youth justice programs don't know where they come from. And we have got a real it's an issue for us in community to actually find out where a lot of the kids come from. So we'll continue to work. We'll do everything we can to make sure that they don't get left behind in the system if we can.
Ani, in your role, you have supported young people going to court, and you've given an example in your outline of evidence that I was hoping you would share today. Can you tell us about the youngest child you've ever worked with, how old they were and what their circumstances were and what ended up happening with them?
Yeah, it was a fair while ago when I first went into my role as a Koori youth justice worker, and it was actually in a Koori court setting. And the young person was 9-year-old, and it actually got locked up overnight, and he was at court in the morning, and he had no support. I don't know if his mother even knew, and I'm not going to judge her for anything, but she wasn't there. And I actually cried, because there's nothing worse than seeing a little fella, a little person sitting there. He has no idea. You know, he got picked up for, I think he might have stole something. I can't even remember that. All I know is that he was there. And one of the things that I do for every child, if they ain't got the support at court, and especially Koori court, I'll take the seat beside them and I'll hold their hand or whatever. And he didn't have anyone. I sat with him. I was crying like a baby beside him, because there's enough, it was disheartening. And he was crying. He was distressed because he had no one with him. And he ended up getting locked up again, I think, because he had no one around him to take him home. And he after that incident, I know he got released, and he'd never got into trouble again for a fair few years. And I'm talking about 9-year-old to 10 year difference. And he did something silly when he was 19. And he did a bit of time for it, but he has stayed really good since. But that circumstance was probably one of the hardest I'd have ever had to deal with, because a 9-year-old in court, a 9-year-old been locked up.
Thanks, Ani. Alan Thorpe, I invite you to introduce yourself, and personally and professionally, and explain the work that Dadi Manwaro does with Aboriginal men.
Thank you. Alan Thorpe, I'm a Gunai man. Grew up in Wurundjeri country. I actually grew up in this street, Fitzroy, Gertrude Street, as a 6-year-old kid. I lived in George Street when I was a kid, so this street meant a lot to me in the community, and a lot of my teachings come from there, and so I was really lucky and grateful for that, that I grew up in community and felt that nurturing support and get them teachings, and so that's how I want to live my life today, because that was a good foundation for me. So I'm really privileged in that way, and so just on a journey, like a lot of people, carry a lot of pain as well. So I went on sort of intergenerational that trauma and just that historical pain that we carry is something I'm really passionate about, is to regulate and to clear so we can live our lives and feel free from that. And so I'm really fascinated, but I'm also willing to learn and willing to work with that space and heal. So that's just something I really love doing, and learning about on the journey.
And how does that relate to the work that Dadi Munwara does? It sounds like that's also a journey that a lot of the clients, or you encourage a lot of the clients to take the first steps on.
Yeah, well, I think for me it was working and growing up in community and seeing organisation and working in the AOD space and seeing the trauma and seeing the same cycles. I was sort of, you see, it was repetitive, and it was sad seeing the same people go through detox 20 times in the same system, and I just thought, geez, there's got to be something different. What system are we following, you know? And so I wanted to explore more, and so when I remember when I first went to government, I said, I want to do healing work. And they go, what's that? They didn't understand the language, but they didn't understand the meaning, and I was a bit stuck. And then I sort of talked about healing and change, and particularly men taking responsibility and being the father and being the role models, which we were lacking as well. And so they put me in this, they said they were sort of stuck, you know, where do I fit in the system? But I sort of went into the family violence because dealing with men who are high dependent and high levels of trauma, but all them complexities with all the housing and family violence and all the drug and alcohol, the high dependency stuff, and so I sort of thought, they put me in that space, but then they wanted to tell me how I'm going to do it. And I said, well, I don't want to do it that way. So we struggled for funding for 10 years, because I didn't want to take the no to violence or the Duluth model and just run that model. And so I wanted healing in our model. And so I didn't compromise that, and I didn't want to take the money for that reason, just to fit in a model. And so, yeah, we developed and evolved over time, but it was at a cost, time, but also financially. But we learned a lot, you know. It was probably a blessing in a way, you know, because we didn't compromise that. And self-determination for me is not just compromising yourself. It's about doing it's about your integrity, and it's about being authentic and doing what's going to work for our people. And so, yeah, I did that, and I don't want to go too deep in the story because I'll speak here all day, but I'm just trying to give you a bit of a journey, and so the Deloitte's report and all the other evaluation speaks for itself, the outcomes. But I think that was the foundation, is about taking the learnings around self-determination, about what it meant and the spirit of that, and actually living it and doing what's real and not compromising ourselves with the system. And so even though we still have challenges with the system, but that's how people did it, you know, that's how we struggled, you know, and that community spirit and that the things that people sacrifice their life for other community. And that's what we did. And so, yeah, it's probably the reason that for Dadi, that's probably the reason we get the outcomes we get, is because of that. We're going back to that. It's like come full circle for me. And so, yeah.
So it sounds like the model you see for self-determination is not Aboriginal organisations being given money and told what to do with it, but it's you in the design seat deciding what you should do and then that being funded.
I believe the models work the best, and it worked for our people. I don't know what's happened in these last 20, 30 years, but for me that was what worked. And our voices and the sovereignty and all the things that we had, you know, over years we lost that, I believe, you know, and I'll never lose my sovereignty. I'm always a sovereign man, and I'll stay true to that, you know, and that's how I operate.
Thanks, Emily. Corey, could you introduce yourself, and if you... Dadi Munwara sounds like it runs a huge number of programs, but perhaps if you can speak to, you know, the ones you're proudest of, I suppose.
Yeah, thank you. My name's Corey Thorpe. I'm a proud Yoorrook Gunai Gunijamara Wurundjeri man, and Wamba Wamba. I'm very passionate about who I am and where I come from. Growing up on Wurundjeri country, and both my mother and father's family have done a wealth of work in community, as Al was saying, and Auntie Karen and cousin Nakia, as we'll allude to later, is that I'm very great. I have lots of gratitude to be in this space now from a lot of the learnings that I've seen and from my parents and my great grandparents, and I've come full circle. Like Sean, I was a plumber for 10 years, so there must be something in that for blackfellas. There's a few of us. But that was from my dad and my grandmother instilling, and Al's father around work ethic and understanding that, that's you can't take that away from you. And I think that was ingrained into me as a young person, seeing family and a community fight for what we believe we deserve, and having that autonomy is what we held early days, and I seen that through Victoria Stars Gym and the birth of the Victorian Aboriginal Health Service when I was young, and the Koori Information Centre, and all of these other spaces. And I was a kid, but I took as much as I could. I've always connected with Al, older cousin. Some people think that we're father and son sometimes, but we are related, closely related, and we have great conversations. And our first interaction was back in when I was about 20. Al asked me to come and to take his role on over at Nguala and work with the Jambi and Titters program, which is working with youth coming out of incarceration and support around reconnection to community and to country. And I was very naive and thought this was going to be an amazing process. And then I realised the structure that program was part of, and the things that we could do and the things that we couldn't do was like really frustrating. But I loved the opportunity. Al seen that in me, and I think he's been very fortunate to work with him for the last 6 years, and I think he's seen something in me a long time ago, which is grateful for. And I've been at Darty for 6 years now, and it's grown from strength to strength. And the evolution of Darty is very representational of that's a cultural process of dealing with the issues in the environment that are at hand at that time. So we do build a lot of programs to suit for what the landscape is bringing. And through COVID, we built a brother-to-brother line, which is a phone line dedicated for Aboriginal men to speak and to call if they needed support through COVID times when, there was a lot of pressures, there was a lot of family connection points, there's a lot of changes that were happening. There was more families being stuck at home together. What does that look like? We've got that program. We have another passion of mine is our youth program, which is our Bramangjan, and I see that as two very big programs of ours. It's a prevention program, but it's an empowerment program around. And you've heard the others speak about the lack of identity, the need for it, and how that is something that we need to put at the crux of all our programs to make sure that we connect in, because that's one of the things that was taken from us, is that how do we actually connect back to connection of country on land, and how do we walk those two spaces in today's society and our own stuff that we're still dealing with, the intergenerational trauma of it all. So, and we continually talk about new programs and new initiatives, and but that's all from the connection with our community members. We learn from them and we hear them, and we then try to enact that change to support that, so that they know that we're invested in in the community, into the work, into to the families. I think that's a really important part of what we do and how we do it. We're statewide, and you know, Annie Karen talked about it, Al talked about it, and it won't be the last talked about, but funding looks different in different spaces, and we see that when we have, you know, Melbourne offices, regional offices. Dandenong is part of Melbourne, but there's very different landscape for funding, and that's a big part of sometimes why the programs are different, but also why you have to be creative. And I think that's the self-determination and the empowerment part of what we do well at Darty, and you know, I can only speak on that part of what we do.
Yeah, it sounds like you're not waiting for anyone to come to you with a bucket of money to tell you what to do, though, that in fact you're always generating ideas and finding a way to do it regardless of funding. Yeah,
I think there's a power in that, you know, to feel that you can lead and have autonomy on building that process. It also gives you the responsibility and accountability to it, because, you know, we're in the space for Darty, but we're afforded by communities. We, you know, the community have elected us to be in that space, especially in our regional offices, and we work closely with the community. You know, Al's specifically put the offices in the regions, in the rural areas where community have asked us to be. We don't go and be a part of that without, you know, consultation with community, or we're always talking with the local co-ops and, you know, the justice and the people working in the justice space, and you know, we get conversations around that as well, and that's part of, you know, the empowerment that we get, and it's also, you know, there's a level of risk involved in that, but that then brings that you have to be accountable to making sure, you know, you do it the right way for community to be effectively useful for what they get out of it, and then also making sure that we, you know, cross the T's and dot the I's for the purposes of the funding and where we get the funding from. So.
Thanks. Mr. Firebrace, please introduce yourself personally and professionally, and if you would, I mean, VACA is a huge organisation. We've also heard from Auntie Muriel already, so it'd be great if you would focus on the Youth Through Care program, and then after that, you wanted to read a statement.
Correct. Biam ingau loichpa glio kananja wadri kulu nation waka glio kananja commissioners ngata na yin in the care of Firebrace. Respect to the Kulin Nation people and their lands, Wurundjeri. Respect to the commissioners. My name's Nikhil Firebrace. I'm Yoorrook the Wungi. I currently hold the position as team leader with the Youth Through Care program at VACA. It's a statewide program, and we work in the pre-release and post-release juvenile justice space. We focus on the core elements of what it is to be First Nations, but more importantly as well, knowledge to be able to retain it. We address that through mental health, we address that through cultural practice, and aligning them with their songline and where they're from. We work with Aboriginal Liaison and other agencies within that space, and we complement their work, making sure that when it goes to the post-release stage, that the young person is appropriately supported and has the supports on the outside. We're a program that initially started as a pilot program in 2019. Subsequently, we have now been Canberra funded, which is a great indicator of the work that we do, but more importantly, the results we get for our young people and families. The cultural element and governance is my role within to make sure that it's protecting our young people's journey. We work in this space to make sure that when it comes to their journey and their voice being heard, we really take that to the next level. But we also make sure that that voice is from the other agencies and the other deadly community echoes that we work with in other programs, that we have a process that supports that as well, a pathway. again, the YTC program is making sure that we have outcomes by going into custody and talking to them directly to find out what is their story and how that looks. We build rapport and respect, and we develop that process that is culturally in tune with what that means for them in the sense of the start of their journey, or what is it they need to know about their culture and where they're from. We're very mindful that when we have people that start that journey, that we don't open up old scars. We're very mindful of how that looks. So we provide that cultural safety and that space in discussion, but also with the people that we work with as well. Our cultural obligations is to make sure that non-Indigenous people understand what that looks like as well. It's a collective effort, and we focus on those elements of what it is to be part of a community that we work in. I'm in a privileged position, but also very much accountable to the community and the family groups. I'm very fortunate that I've grown up with a strong matriarch and patriarchal system. I come from Queens and Kings of the Riverine Nations. The laws that's been passed on to me from them comes from my Dumalas. It comes from them. It's passed on. I'm not talking in the sense of what is new, but what we've been speaking about for thousands of years when it comes to the integrity of our law. Each male in particular has a role of responsibility of title, understanding what that looks like, understanding that our queens are our mothers, our sisters, our daughters. We need to be able to fulfill a space that when it comes to the culture strengthening, is that when I work with young people in custody, is to have a discussion what that looks like. Fulfilling their cultural identity and role through practice. The integrity of that, it comes from members of community that are endorsed, elders of council, and members that are respected. The accountability is not so much something that is taken consideration because it can be looked at as authority. I don't agree with that. Elders don't agree with that. It's accountability to the process of knowing who you are and where you're from. Return to countries is one thing that we focus on when that young person is ready. Preparations. Do not tick a box with our young fellas, men and women that are going through that process. It may be multiple journeys required, and each step required as accordingly when it comes to the guidance of that Council of Elders. The voice of the young person is a huge part of that, leading it and being aware of it at all times. We're there to reduce recidivism, but we're also there to make sure that is started by understanding their identity first and practice. You ask me, I ask them where you are from. And this question comes from the elders, how? It is my responsibility as Yoorrook, but also as a First Nations man working in this program, that the accountability of cultural integrity is focused on. Youth through care is a way that we're able to facilitate and support our kids in custody. But this discussion's been happening for a very long time. And I raise those words on behalf of those elders and our community leaders now and in the past. That our way of culture works. We have multiple case studies within the YTC program. Our team, non-Indigenous and Indigenous, work collaboratively together on the basis of cultural safety and integrity. So over time, as we continue to work with our deadly brothers and sisters, non-Indigenous or not, and our deadly brothers and sister girls in other agencies, community, we'll keep doing this. So I'm blessed to be able to be in the position as a Yoorrook man, but also work in the space at VACA, in the Youth Free Care Program.
Thank you, Mr. Firebrace. There were a number of common themes in all of your work, and so there were some general questions that I'll ask the panel, and you're all welcome to answer. And Mr. Braybrook, as you're on screen, I'll check in with you before we move on to the next question, to make sure you get an opportunity with respect to each question. The first question I wanted to ask was in relation to who's accessing your services. What do you see as the major issues or the major characteristics that are resulting in First Nations peoples being caught up in the criminal justice system?
Trust. Young people in our families have been betrayed and lost trust in the past. From government authority positions, from police to services. The breakdown of communication and the breakdown of the cultural lens and cultural safety in that space.
I was going to just talk about the young people. A lot of the young people that we have coming through ours are children of child protection already, and they're in resi care units and stuff. And one of the things is they have a big care team already that they feel like doesn't do a lot for them. So I think that's where we need to step into our spaces, make sure that we can build that cultural integrity within there. But it is a lot of the kids' sense of belonging and where do they come from? How do I know? And I know we can do cultural support plans for the kids that are young. Like I work with young youth justice kids. It's different. A lot of them can come with some information, but we can also help them with the information. So it is really around that cultural integrity stuff and where do they come from? How do we support them? And it is that trusting stuff because they've already had a big heap of people involved in their life as little people and they're growing still. So it is managing that stuff for them, and that trusting is, like Nakia said, is a big issue. So many of our kids have had people in there that they say they're meant to work with them and want the best outcome for them, but at the same time they're stomping all over them and treating them badly. So, and that's a true statement that I can make, that I really know that happens out there, because we don't get the best outcome while you're telling kids how to do it. You need to work with them and see what works for them.
In the adult space?
Yeah, I think it's just not one contributor. I think there's multiple contributors, and I think one of the things what we find and what we've discovered with transformation and change is the intergenerational trauma, is the historical, like the pain and the suffering that our people are carrying for many, many years, you know, and I think, and all the abuse and all the things that have come from the system, from, you know, all that sort of holistic. So there's multiple contributors that our people are driven underneath all that dependency and violence and all the other things, the acting out. There's a level of pain, level of and that sense of belonging and sense of sense of self, like not knowing who they are, you know, and just that's part of the system. But I think for transformation, I think that's what I see works the best.
Yeah, I think exactly what Al was saying. The trauma that's carried through generations, and you know, we know now that's carried in the blood. You know, we're in Victoria, 3 generations removed from living off country. So, you know, that violence of disruption and colonisation is carried through, and the lack of responsibility taken from all sides. No one wants that responsibility. So it's a lot of finger pointing, a lot of how do you deal with that pain when that emotional pain is always really raw and it doesn't subside. And we see that come through with the families, with the young people, with the partners, and it's a lack of connection, identity. There's so many ripple effects that we see, and I think the thing that we try to embed into it is just doing the work, you know, slowing them down, having a simple thing that we do when we do have that is just trying to have a coffee and hold them in a space just to have the conversation, because there's all these contributing factors that we have to address, and you can't address them all at the same time, which is sometimes what they want, but, you know, I'm still dealing with my own, and if I'm still dealing with them and we've still got people dealing with bigger stuff or more complex stuff.
Mr. Braybrook, was there anything you wanted to add?
Yeah, definitely. I'd like to add some stuff to this as well. Definitely agree with all the other speakers, and we touch on very general terms about it all. Probably the things that I see as well, and we this journey of when we built Woolgunga and the community were against us as well, didn't want an Aboriginal facility in the backyard. So real big story to tell about that. But the things that I'd like to say is everyone knows the common themes, the education, employment, and all that sort of stuff. The things that we see and the things that we've learnt a lot about, where we try to strengthen our men and even work with the community around, is number one is stigma. The stigma of people that have been in the justice system, the stigma of Aboriginal people. So we look to build that up here at Woolgunga. We do a lot of community activities. We've invited the community out, participate in our activities on site with Aboriginal men and really show that positive side. So that stigma can play a big role, and especially when you carry that as well. Ignorance is a big thing. You know, people not fully understanding what we're about, what Aboriginal people are about, and that sort of stuff. That's also been a big work. Really learnt this a lot when we built Woolgunga, when we heard a lot of the same stories of don't want an Aboriginal facility in your backyard, you know, all your staff are going to be drunk, and all these sorts of things through community consultation that we'd hear. Then when we rolled up our sleeves and got in and actually worked with these people and understood what they were going on about, because we set up a little community advisory group, you really start to understand that it was just ignorance. People didn't know. Now, once you share that culture, share that identity, that really changed a lot and really had that great impact on the work that we do. So I see that as a big thing as well. The other one that I'd like to share is just opportunities. Where's our opportunities? You know, I touched on it earlier and Corey touched on it. You know, I benefited from, as a young Aboriginal kid that was struggling through life, and got an opportunity as a plumber. None of my parents worked as plumbers. None of mine worked in the industry or anything like that. And, you know, I got that leg up there and that really helped me support. So opportunities are a big thing that I see. You know, lack of opportunities for our men, lack of opportunity for our women, lack of opportunities in the system. And then the last one, I always have to throw resources in there. You know, resources hold us back. You know, I'm a big believer about, you know, investing in community-led initiatives, community programs, prevention programs, intervention, early intervention, and all the stuff that goes with that. And then the last one, especially the work that we do and we see and hear Alan and Corey talk a lot about this and as well, about that transgender trauma. You know, the trauma that's being passed down through the removal policies and the Black Australia, White Australia policies and all that sort of stuff, the impact that has on our men and on our people as well. That's very important. So they're the things that I see with the men we work with. And we try to take a focus on them as well.
Thanks. The next question I was going to ask related to cultural safety, and so if you have any if you wanted to contribute on that, and I might come to you first. And that question is, how do you ensure cultural safety in your services, particularly given that you are operating within a system that we've heard is very culturally unsafe?
Yeah, this is a really great question, and we've worked really hard on this, especially in the early days. Woolgunga was born probably about 2003, probably even had discussions back in 2001 about what it would look like and that sort of stuff. So the key to us is being born through the Aboriginal Justice Agreement. So we're overseen by an Aboriginal Steering Committee, and especially in the early days, and lots of people would know the names in the Steering Committee around, which I won't mention, strong Aboriginal people, leaders within our community then, that really shaped what we were going to be and how we're going to be about it. And then we brought the department along on the journey. So that was that sort of way around that. So cultural safety has been a very important part and important to be able to handle that. And one of the big things from the steering committee that oversees this is for the place to be voluntary. So what we didn't want to do, we didn't want to build another prison. So the place is voluntary. So every man chooses to be here, which that's very important. very important. So chooses to be here. So that's one of the really important things that come from that as well. And then the support mechanisms, like men out here, we don't charge men to be here. Being the Department of Justice, men don't get subsidies taken out of their Centrelink payments. Men are encouraged to save, men are encouraged to spend, send money back home to the loved ones and send money back home to the people that they need, but also talk to them about their budgeting stuff. So that's a very important part as well for our program. And when you talk about cultural safety, I suppose I can tell you some of the key aspects to us, and these are the things that we share with the department and share with the way that we move it around as well. So first of all, I mentioned about supporting the man, strengthening the cultural identity and addressing the behaviour. Yeah, so that's a real big focus for us. We have to get it right, and we have to get it right in that sequence as well. So that's that cultural strengthening, cultural safety. The second part to it is we take a holistic approach. Yeah, so we're looking at the individual. What does that individual need whilst he's in the program? Yes, we have a set that we run by and we work by, but what's that individual need? And we really focus on that and giving that individual that support that he needs to move through. Cultural strengthening process is at the core of what we do. Someone comes into the place, we have a welcome ceremony, someone leaves, graduates, finishes up, goes home early, whatever it is. We do a cultural ceremony for them to leave. So very important for us to have that in the heart of the place as well. And that's that fire pit that sits in the middle as well. Aboriginal inputs, being Aboriginal input from the beginning. So very important, if you're going to build a Department of Justice facility, have Aboriginal input. Aboriginal people have got to be a part of the process, and that's what we've done all the way through, and that's how I explained about the steering committee and the rest of it that goes on. Elders and Aboriginal elders come in and provide cultural mentoring support. So link people to Aboriginal elders, and that Aboriginal elders come out here and stay and share that journey and share that way that we move forward. So that's very important within our model and the way that we move forward. And the other thing is all our core staff are Aboriginal men. So in the work that we do in the men's space, yes, we have female workers. We have female workers deliver female program, deliver programs, facilitators and that, which is very important for us to do that as well, because it's about that holistic respect and that. But the core staff are Aboriginal men, yeah, within the place. And let me just elaborate on that as well, is through the day, Wurrungandawu is this mechanism that runs. You know, we have all our staff in the facility, we have all our staff on site, helping men doing this and doing that. Then over night time, I always say that's when the magic of Wurrungandawu is created. When the place is handed back over to the Aboriginal men that are participating in the program, we have one staff member on of the night time, and the place works and runs, and they take ownership of it. You know, so it's very important. So it's Aboriginal led, but then it's handed over to the men as well to take that journey and share that journey. And then the last one, I think I touched on as well. Participation is voluntary. So the men really are here because they want to achieve something, and look at that. That puts a lot of challenges on the work you do, puts a lot of challenges on the facility itself, because if it's a voluntary program and you're not achieving things, men aren't learning stuff, men aren't getting stuff out of it, you're not running for 14 years like we have been. So that's the whole thing about it. So that's that sort of thing that we share with the department a lot around that culture side. In a cultural aspect, if I was sharing it to Aboriginal people in a cultural aspect, it's probably just really simple, 3 processes. Number 1 is order and ritual. So we're big on order and ritual. We do things at the right time and the way that we need to. The other one is respect and responsibility. Yeah. So you take responsibility for your own actions and respect everyone in the place. And then the third one is about passing on the knowledge. As you as an Aboriginal man, you grow in your identity, you grow in what you do and what you understand. It's your responsibility to make sure the next generation has that you've learned and passed on. So that's that sort of fundamental stuff about the work that we do and how we do it there.
Thanks, Mr. Braybrooke. I might just turn to the rest of the panel. The question was about the particular services that you offer and how you ensure that they are that there's cultural safety in how you provide those services.
Yeah, I'm happy to start with that. It's a big one, big question, because safety's really everything, It's the number one, I reckon. trust, that I heard the word trust, and community normally let you know when they don't feel safe. Our mob like speaking, and talking. So your service delivery is number one, you know, how you work with our mob and how they're respected and loved and nurtured. And so and that's number one too. Safety is they're always assessing risks. I mean, you're always looking at the physical space and the spiritual space and who's around, and I mean and the first step is acknowledging their first step to actually come to you. I mean, that's number one. That's another important aspect of this cultural safety is they're seen, and if they're feeling it, they're feeling not only hearing it, but they're feeling it. They're feeling the space. They're feeling the nurturing, and then, you know, being guided by your values about what you stand for as well as an organisation. You know, how we support and your principles around that is a guide as well. About, you know, how and bringing some of them approaches back about why did people come to the service, or why do they come to Darty, and what do they want, you know, and what they're there for, you know, is being able to let them guide a little bit and determine and hear their voices of what they want and what they buy into. And so, yeah, just thinking about what they're there for and being and hearing their ideas of what they want, because you can't fix everything, the connecting, I think, is a big one. Yeah, I think the connection is really important around the relationship you have with the person, and standing for things. You know, what you're clear about, like what you can offer, and not setting people up and giving them that false and pretending that you can do things when you can't, because that's cultural safety too, promising the world and not delivering. So that's the integrity part, you know. So there's a lot to that question, but that's my observation and experience.
Anyone else want to address that?
Yeah, I do. I was going to just mention, for me, it's having Aboriginal people sitting in the space. We say we can self-determination, we can do it for ourselves. So our practice is, I believe, about having the Aboriginal workers to do the work for our guys, for our young people, and it is that you talk about cultural safety. Well, we can deliver a cultural safety program, and we need to nurture that part of it for our young people. But I wanted to even expand a little bit more. So we talk about cultural safety. We are growing in different realms in life, and I also wanted to bring up about cultural safety for the QLGBIT community. And I don't know if I got it right, but I always have a struggle. It's around that as well, because we have a lot of young people who are coming out in community, and we need to be prepared for that, as well as the Aboriginal component of strengthening culture, because they need to still belong in our community regardless. Their Aboriginality is still there regardless whether they're from the LBGQ community. Sorry, I always get it wrong, but I also know that I need to put that part into, because we think about cultural safety for our kids is Aboriginal stuff. It's around other things in our community too, and we hear that more and more. So our services need to be open for all kinds of Aboriginal children and young people. And I think for me, it's having those people there and understanding that that's their choice, and we just have to be there to help them get through all of this stuff in their life, regardless.
Thanks for that reminder, Auntie.
Cultural safety, freedom of choice. Just listen to Uncle talk about voluntary, the power of voluntary, to be a part of something, not because of a court order, not because of bail conditions, but freedom of choice, to be empowered with their identity through spirituality and practice. When it comes to the governance of those steps, officially recognise the power of Council of Elders and each nation respectively. The governing authority will come from their songline. We're fortunate enough where, when it comes to the practice within VACA's YTC, is that we're on the foundations of that within that program. But I only say that because program is a word that's thrown around too easy at times when it's a way of life for us. We're talking about healing and addressing these issues. The knowledge has always been there. So the cultural safety is remembering our elders' teachings and forefathers and patriarch bloodlines. That's cultural safety, freedom of choice.
All of that, what everyone said is amazing. I think for me as well, it's communication of the transparency of what you offer and how you deliver, and all the partners and all the key stakeholders in that, which is the community, the organisations, the co-ops, and how you communicate those and what you're delivering. That's in the crux of it all. That's the going back to the cultural process. Our language is oral, our history is oral and dance and art, and so communication is really key around passing that on. So I think that's a huge part of the cultural safety.
Thanks. The next question I wanted to ask, we've heard a lot about what's really working. What are the key challenges for people coming out of adult or kids' prisons, and what are they finding hard on release? What are the biggest issues you're seeing?
Well, timeframes. I mean, our program is designed to support our kids for up to 2 years, and it does extend depending on when we get the referral before they're 18. So it's that consistency, being there face to face. There's no better feeling when you have a young person, obviously with that transition from custody to post-release, seeing them outside, catching up and doing our normality of culture, having a feed, having discussions, keeping them, how are you going mentally, how are your things processing, not overwhelming them. Over-servicing is not looked at properly enough. Having 15, 20 organisations in one care team when the young person just wants 1 or 2 or 3 things. So it's timeframes and how with the consistency of work that is therapeutical and has intent. If we focus on those things and listen to what the child is, what their journey is, we're able to help reduce the anxiety and trauma that's around that. But from experience seeing that is that when it's done correctly, like some of our children in custody, the longest they've been out is a weekend. So what we work out on the basis of, well, let's work on 3 days. Be realistic about this, about how that actually works. And some of the work that we've done where kids have been in there since 15, 16, 17, they've been out for 2 years, 16 months, 12 months, because we're consistent. We're there face to face in custody, but we do our best work from a cultural perspective, following our governance and teachings of elders on the outside, and our young people gravitate to that.
Anyone else like to address those key issues for people, kids and adults?
Where do you start? The issues with prisons stuff, and I think challenges come from all different angles that we, each prison's different. There's private prisons, there's low, medium and high. The punitive approach to the men and the women that are in prison and the young people. In an instant, a lot of the behaviour change and healing programs that the court orders are a certificate of 14 weeks to then to deliver that they have to be a part of. That in my head, that doesn't make sense. That in 14 weeks or a 12-week program that you'll actually be cured of understanding or what you need to. It's an ongoing thing. That's a life thing. I think having more realistic goals and a more tangible approach. We've had conversations with judges at their school around the actual approach that they have in court before, and have addressed some of the communications, and they've been told that they have a punitive approach for the purpose. Shawnee touched on it earlier, stigma. What happens is that they wear that. That's not cultural process. You deal with, in cultural process for mob, is if you do something wrong, lawman, you're dealt with, and then you're back into the community. You're part of that. Approach that happens right now for prisons is that they may be touched the juvenile justice system, and that affects them for 5 to 6 to 7 years. Lack of opportunity because they have a record, or there's a whole matter of processes that I find that doesn't allow us to connect with our mob to do the necessary work. It actually, CCA orders also hanging over these men's heads that we deal with. That's the stress and anxiety that beats on their mental health, and it actually takes away from the opportunity to be a part of programs like Sean's, which is really important with what we need and what we do at Behaviour Change and Healing, the way we run it. So, we can talk about the issues with the prison stuff, and also I think on the prison side is, the representation of workers in there. It's hard for them. We work closely with the workers. There's 1 or 2 Aboriginal workers, and there's 160 to 180 Aboriginal men in a prison. I don't know if anyone else can do that work, constantly without. That's potentially 50 to 70 different Aboriginal nations that are represented in there, and then to have 2 people or 1 person have the knowledge to actually access and work with each person without being affected. That's the reason why you have high turnover of AWOs in prison system. There are good things, but the question is, what are the challenges? So
you touched there, Corey, on there being 2 workers for 50 different nations. Mr. Firebrace, you've confronted this challenge in juvenile justice. Is obviously you're one man and you're dealing with kids from a whole range of different areas. How are you dealing with, you obviously don't have cultural authority for all of those different children's mobs. How are you dealing with that issue?
Protocol. First and foremost, when it's not my nation, follow protocol and get in contact with those members from that nation. But I'm in a position where I can also delegate, but I'm also making sure that that information that I pass on to the team is culturally safe and informative. And that's where being able to facilitate that discussion with the staff is to make sure that we have intent to support that young person's goals, but also how it looks before they're released, and follow up with the same work on the outside. So it is a combination, and having that cultural accountability to that, to make sure that it's done appropriately and safely for all. Yes, it's a therapeutic, but it takes time to be done properly. And again, it starts off with protocol. You can't have discussions with a young person if you haven't sought permission around songline in particular, or law, and what that looks like. Everything from including their artwork. And it happens. You see that they're doing stuff that's not even from their country because that's the only thing they've been shown. So again, in alignment where they're from, to heal their malana, their spirit, is to follow protocol. And that's where it comes to my role, first and foremost, as Yoorrook, as First Nations, is to make sure that that's done, not only within my life, but in my workplace. And I have that cultural obligation to make sure that staff understand that. And they do. I'm blessed to have a great team in the program, but also an organisation that supports that vision on how we're going to protect our children.
It sounds, there are similar issues arising in the child protection space in relation to cultural plans. The idea that a white fella in the department could, put together a cultural plan from Wikipedia, and it sounds as though also for the young people that you're working with, that it's not a quick answer that you can, look up on the computer. It involves a journey to go and visit some people. Or
thank you for pointing that out, because it happens. They
Yeah.
Google it. Mm-hmm. That's only because that's the only thing they know. Again, my position is not to drag them over hot coals and make them feel. They're in a position because, 1, they're passionate, and 2, they want to make a difference in a child's life. So my role is to show them why, but also point out the points they can't talk about and make sure it's done in a way that they understood reasons behind that. So we can have a partnership, but there is strict protocols that prevent them talking about particular things because of law. And that needs to be led and guided by the council where their nation is from. Therefore, the true songline of where they're from is properly connected because we are very, very spiritual people. When we have someone from overseas, from a different nation, doesn't matter where they are within this country, as long as their elders are informed, that song line goes to that young person. I've seen it myself from a young person in Victoria in the prison system, juvenile justice for 5-6 years. But he's from Tiwi Island. We done things appropriate and it changed his view on that things can change. And the team on how it's better informed and better supportive. And we got things done. But the point is that protocol needs to be understood. And for those people that are non-Indigenous brothers and sisters that work together in our services and have that passion and that vision as well, we need to make sure that discussion is done appropriately to protect them as well. Because we want to be able to have things moving forward, not mistakes done because they haven't been informed appropriately.
Mr. Braybrooke, was there anything you wanted to add in relation to this, the question about the key challenges for people coming out of, for you, I suppose, it's generally been adults' prisons. You're obviously seeing men at the point at which they are on a community corrections order. What are you seeing are the main challenges for men after a prison sentence?
Definitely there's lots of challenges, and I think everyone's named a lot of them too, you know, and the normal challenges when you get out, no housing, no accommodation and all that sort of stuff that goes along with that. But I think that we're not getting men ready to come out. Men that are in the system, they're not ready to leave. You know, and next thing they're standing in front of the door that rolls up, they're looking underneath to see there's officers waiting for them at the other side. Next thing they're out. You know, so that real readiness to go out and the pressures of life that comes with that. When we talk about the stigma, we talk about ignorance and we talk about all that. It's all that pressure. So I think there's a real area we need to focus on a lot in that. We need to get that right. You know, my whole thing would be let's do that at the front of it, stop them from getting in there first before coming out. But that definitely getting fellas ready to come out. We see it a lot here at Woogunnalu, where predominantly we were set up to work with men on corrections orders to stop them from going into the prison system. And then we've seen the government change and suspended sentences get abolished. And we see a lot of men going into prison and coming out on a corrections order. So there's this whole suspended sentence on term of imprisonment and that sort of stuff. So that really changed our focus here at Woogunnalu, where we're working at the front end, stopping men from going into prison, to now seeing a lot of men come. We still have men that haven't been to prison come to us, but we see a lot now that are having these short terms, maybe a little bit longer terms coming to us from prison. So some of the things we had to think about a lot in that sense is the work really changed for us. And men that come out of prison come out with a lot of baggage still, you know, with the prison environment and the way the prison runs and everything else. The trust is a big one. So we work really hard on building up core and the trust. You know, we have a thing that we call a 21-day plan. So and that's just for the staff. It's not for anyone else, and it's for the staff. So when someone comes to us from prison, we're doing things like we're making doctor's appointments in advance rather than asking us. We're looking to monitor their behaviour, watch and see how they're acting, how they're interacting with people, interactions with people and that as well. So a common thing is someone might come to us from prison and the place is running, then all of a sudden you see 5 or 6 blokes in a massive big property walking backwards and forwards over a 5-metre strap, you know? So we really work hard at challenging that prison environment, that prison baggage that they come out with. So me, it's all about really getting men ready to come out. And even they come out, they get a mobile phone, they hook up to Facebook, you know, and they find out all this goss that they're not privileged to within the prison, or they just shut off about and stuff like that. So some of them real pressures that you find, and real life pressures that go along with that. So we work really hard in that space.
Thank you, Mr. Braybrooke. I think that is the end of the questions. I'm sorry, I've just realised the time also, but of course the commissioners may well have some questions, and I'll hand over to you, Chair.
Yeah, just make sure it's on. Thank you all for all your evidence. It's very enlightening. You all mentioned about identity, and as a understanding who you belong to, where you come from, and I guess as Aboriginal people we know that's a strength, and I think you've all mentioned that. You've also mentioned the cultural support plan, so you answered one of my questions. But the identity work and linking people up, is that funded or is that just what you do?
With the youth justice funding that we get, it's a part of our funding that we actually have to do cultural support plans for every young person that comes to our service.
Can I ask, Arnie, are they generally from out-of-home care system, or?
It's a different, no. So we've got a different one for youth justice that is separate to a child protection one, so they're clear differences.
They could have two?
They could have two.
Okay. Do they speak to each other?
Not necessarily, because when you have a look at a child protection one, it's generic to the area where their family come from. It's not generic to them or their family per se. So we aim ours at their family tree, their family connections. What have their family done that's some good things in community? And nurturing that part rather than just the generic one that tells them about their area and everything else. So we try really hard to put in something about them and their family that is some part of history, you would hope. And a lot of them don't have anything, but it's something we try to do.
Question? Yeah, look, thank you for all of this. We've heard over the last couple of weeks with child protection and in the criminal justice system is the sort of idea that somehow just getting an Aboriginal service to deliver a program that's been framed by non-Indigenous perspectives like Yoorrook and even models that have come from overseas that aren't even Australian doesn't work. And you've all talked about your own development of programs that are based around the people, culture and identity and what people actually need. Do you think that government departments and funding bodies are getting better at understanding that just giving a Western model to an Indigenous service, an Aboriginal service, is going to improve things, or are they starting to understand? And the answer can be yes or no here, or maybe that's not self-determination and it's probably not effective program delivery.
I'd say in some areas they may be getting better, in some because funded programs. So navigating that's not always easy, but it comes back to relationships as well within government. And I'd say, just from my experience, and people move around in government, so you lose them as well. And they start to understand and they connect. It depends on the personality and the person in government, and that's a contributor. And I think, yeah, some governments you go to health and they'll treat you differently, and then you go to DFFH, they'll treat you different again. So there's no consistency. And I'd say, and that's just my feedback.
I was going to say, I think we feed a lot into government. We're always giving government lots of recommendations on how they should do things for Aboriginal community. One of the things, I just lost my train of thought really quickly. Sorry. Oh, okay, no, I got it, because it's really something I need to be passionate about. We do the work in our community because we love our community. We want to make our people better. We seriously do want to make our people better. Government want to give us funding to do it, but they only want to give us half the funding to do it and expect us to do more. So they actually pay their workers in the government big money to tell us how to do it, to try and tell us how to do it. And we get the little pittance to go and do the hard yards. So I think we need to talk about pay parity for the work that we do in our community, because it actually doesn't sit that we do all this work and we do it because we love them. We seriously do, and we want to see the change in our community and in our mobs. And if we got paid or got the funding appropriate, we could deliver more culturally appropriate services, but we get little dribs and drabs. And I'll give you a really good example of what's happened in the last couple of years. Every year, the last 2 years, 3 years, I've been offered funding to run a school holiday program. But guess what? They'd give me a call on the day that I'm going on leave, on the 20th of December every year, say, I got 10 grand for you, I got 5 grand. And that comes to me, but lucky I'll get on the front foot. I've already got a program developed to do the holiday program because I know they might come to me again. So right now I'm sitting waiting for funding for holiday program that I can run for my kids. I've got a program developed, I'm just waiting to see if they're going to give me a call on the 20th to say, yeah, you've got some money for you. But they're the things that I'm...
Christmas comes the same time every year.
Yeah.
So if they're listening today, maybe they could call you this afternoon.
Be fantastic. No.
Just in regards to that, I'd like to respond in the sense of we've had so many advisory committees over the years, everything from Black Deaths in Custody, recommendations to that commission, Royal Commission. How many of them have been followed up?
Yeah.
We've had these things around for such a long, the age, raising the legal age of responsibility, the empowerment of community, of elders, the governance around that. So the biggest problem is that what we have and what we face is in who's in power. Which government really determines which funding is allocated and how much that is. So it really comes down to if it's Liberal or Labor, as an example. That can affect what happens in each state under those voting processes. So that's an issue in itself, is that we're fortunate enough that we had a government in Victoria for a 3-year term that we're able to facilitate the things that we are discussing. But it's not the same in every state. I just recently came from a conference of legal and justice in Tasmania, Hobart, of the Lewitra, of the Palawakane people. Incredible. And we discussed about why is it that the only time we have momentum is when a government in particular politics is in power. That's an issue. So that should not be a way that affects our empowerment and our laws and customary practices. That should not be reduced by anyone in that space. It should be just federally legislated. It's relevant. This is what we're going to do to support First Nations people in this country.
Thank you very much.
I'd just like to add something to that, if I could.
Yes, Ms. Braybrook.
Yeah, thank you. I reckon it's a really great question, and the question, if I can remember, because it was a while ago, was if mainstream programs being pushed onto Aboriginal people could work. Is that basically the question?
It was more about whether departments are learning that that's not the model and whether they're changing their openness and their flexibility about Aboriginal
so it's more
programs
around
instead.
departments and that as well. I think there is some growth in this area, and I see it a little bit about making some of the programs culturally friendly and implemented by Aboriginal people, but follow that model. And the things that I've seen a little bit is the identity of the program, having Aboriginal people in it, co-facilitators in that as well. So an Aboriginal person and a non-Indigenous person, I think, can work. So in that sort of thing, identity of the group being formed as an Aboriginal group, Aboriginal people within it. But the real thing that I think that really makes it out is when you're talking about these sorts of things, I think it's a lot to do with the delivery of the program and the person delivering it. Yeah? And especially that's what we see at Wulgunga. If we're running some programs that might be a little bit mainstream focused, if that person in the group isn't culturally safe or culturally aware or anything like that, the fellas see it straight away. I always say it's real knows real. Yeah? And that's where you really break down, that's where you fall down in them areas. So that's what I say a lot. But I definitely reckon there's some learnings to have, and as long as programs are open to an Aboriginal way about doing stuff as well, and an Aboriginal way of thinking around things as well.
Thanks, Mr. Braybrook.
Can I just add just one thing I wanted to bring up? What I love about transformative and our people in them systems, in justice systems, they always want to come back to community, not only to get a support, but they actually want to work. Mm-hmm. They want to be part of community. They want to give back. And there's these blockers, these systems that don't allow us working with children, doesn't create opportunities for our people and our mob to actually, that's part of integrating. Mm-hmm. Part of integrating is finding your purpose and what you want to do. And I wanted to put that in there because I'd love to see the system pay more attention to that about opportunities for a mob, because I reckon one of the game changers is when they come and work, when they've done the program, or they've come out of prison and then they want to they've done some good work. Not everyone comes out. Some people do really well. But can we open up opportunities for lived experience and our mob to create them opportunities? So I hope that's discussed, because they become the best workers because they're really hungry and their intentions are really strong about wanting to give back. And we have the bureaucracy and we have the systems that block the people from them opportunities. So hopefully that can be talked about more.
I think we have one more question here, please. Or
Mine was just a bit of a technical question. And Mr. Fibros, I just wanted to, does your program work with kids in youth justice? Am I correct? Yep.
Correct.
For 2 years?
Correct.
Under 18? Like, is there an age limit?
Well, as long as we get the referral before they turn 18, we can look after them right up to 19 years of age.
And so if they come out of home care, where does the case management sit?
Out of home care, well, VACA is a very big organisation. So we do refer internally, and we make sure that if they happen to be for resi care, whatnot, I mean, we focus on making sure we keep them out of custody. And whatever that child's needs is, we make sure we refer directly to that organisation or team. So, does that answer your question?
No, I was just wondering, when they're in out-of-home care and they go into, because I've heard evidence all week around the pipeline of going into youth justice and then on to adult prison, is there a continuity of workers? I know you have a care team.
Correct, yes.
So is there a continuity of workers that sort of go...
Part of that, yes. Yeah, they are part of those discussions in the care team, because if they're already placed, we want to make sure that our work that we do with an outreach perspective is followed on to support that process or placement.
Great, thank you. Thank you so much.
Thank you.
Any more questions?
No, thank you, Councillor.
Thank you, Commissioners. I should tender those outlines of evidence. I'll now tender into evidence the witness outline of Alan Thorpe and Corey Thorpe, Exhibit 7.2 and following, which are documents referred to in that outline, and the witness outline of Sean Braybrook and its attachments, which is 7.3, the witness outline of Arnie Karen Williams, which is 7.4 and following, the attached documents, and the witness outline of Nakia Fibrace, which is 7.5.
Thank you. Those will be allocated the appropriate exhibit numbers. Commissioner.
Thank you, Chair. I think we might be overdue for a lunch break. Apologies.
Yes, I think it's break time, and thank you all very, very much.
Thank you.
Thank you, Sean, very much. Sean or Shane?
Sean.
Thank you all.
Thank you.
Thanks, Mr. Braybrook.
We will read at what time is it, 1 or 2 o'clock?
We have witnesses representing the Victorian Aboriginal Legal Service, or VALS, and I call Narita Waite, Kin Leong, Anna Gibson and Sarah Schwartz. Madeline Stenmark is listed to appear, but she's not present. She's not appearing today. And they are seated in the witness area to my left. I will proceed to swear them in, and we can commence evidence if the commissioners are ready.
Thank you.
I'll start with
some discussion about who's appearing.
Madeline's our comms officer, so we were just a little bit confused as to why she was on the list. She is wonderfully informative, but wasn't...
That explains everything. Thank you.
Thank you. So, firstly, Ms. Narita Waite, if you could just say your full name for the commissioners, please.
Sure. Narita Nolly Mary Waite.
And in the evidence you are to give to this hearing, you undertake to tell the truth?
Yes, I do.
Thank you. Mr. Kin Leong?
Charles Chi Kin Leong.
And in the evidence you're about to give, you undertake to tell the truth to the Commission?
Yes, I do.
Ms. Sarah Schwartz?
Yes, Sarah Schwartz.
And do you undertake to tell the truth in the evidence you're about to give to the Commission?
Yes.
And Ms Anna Gibson?
Yes, Anna Elizabeth Gibson.
And do you undertake to tell the truth in the evidence you're about to give to the Commission?
Yes, I do.
Thank you. Commissioners, I understand that Ms Waite would like to make an opening statement, and I'm grateful to her for making that, if she's ready to proceed.
Yes, and thank you for entertaining my request. First, I would like to begin by acknowledging the traditional owners of the land I'm on today, the Wurundjeri people, and I pay my respects to the elders past and present and Aboriginal people here today. Aboriginal and Torres Strait Islander people never ceded their sovereignty. It always was and always will be Aboriginal land. I'm Narita Waite, a proud Yorta and Nurrinjeri woman, and also have connections to Tanarong through my great-grandmother, Mary Hamilton, who later became Mary James. I'm the CEO of the Victorian Aboriginal Legal Service, which has provided and continues to provide culturally safe legal and justice services to Aboriginal communities across Victoria for the past 50 years. I'm also the mother to two beautiful little boys, aged 5 and 1. I'm joined today by my principal managing lawyers from VALS, King Leon, who manages our criminal practice, Sweara Swartz, who heads up our Wirraway unit, and Anna Gibson, who heads up the Ballitnaloo Legal Service, which is our service for Aboriginal children. I would like to thank the Yoorrook Justice Commission for the invitation to appear today. We've prepared submissions for the Commission on the criminal, legal and child protection areas. I would like to begin our evidence by outlining our vision for an Aboriginal-led justice system and the critical need to transfer power, control and resources through a justice treaty with Aboriginal communities. The reason we need a justice treaty is that our legal system needs total transformation, not piecemeal reform. We cannot continue to make flowers out of weeds. The legal system has been central to the oppression of our people by the colony since the first day the British arrived. From Terry Nullis to the denial of citizenship to the way the legal system enabled hundreds of massacres and then evolved to create the stolen generations, the legal system has been a tool for killing and enslaving Aboriginal people and erasing our culture and traditions. In the face of a legal system that has always hurt us, Aboriginal and other communities in Victoria have consistently demanded self-determination, from William Barak's struggle to save Corranderk in 1880 to William Cooper's petition to King George V in 1936 to the powerful recommendations for self-determination from the Royal Commission to Aboriginals in custody. Aboriginal communities have always been ready to fight for our rights and take control of our own affairs. Over the past 20 years, the Aboriginal Justice Caucus has also been a consistent voice for greater self-determination through Victoria's Aboriginal Justice Agreement. The current government is committed to the principle of self-determination, but in reality, the power imbalance between Aboriginal communities and the government remains. Our communities and organisations remain in the background. We're simply an afterthought, a tick-the-box exercise. The lives lost remain in the shadows and their families' calls for justice go unanswered. It is time for Aboriginal communities to exercise their right to self-determination in a way that is meaningful, holistically and legally enforceable. A justice treaty's opportunity to aim for transformational change, to repair the harms caused by the colonial legal system, which can never be effectively mitigated, but can only be transformed. Justice starts with the way that we're recognised within the law. First Peoples need to be restored to their rightful place, with their inherent rights respected and promoted, which derive from their political, economic and social structures, from our cultures, our spiritual traditions, our histories, our philosophies, and especially our rights to our lands, territories and resources. Australian society desperately needs to eradicate racism in all its forms. To achieve this, we need to aim higher than merely mitigating the harms of the colonial legal system. Yoorrook's recommendation should be directed at restoring First Nations peoples as decision makers in their own affairs. The vision of a justice treaty is for a new legal system that is designed, led and controlled by communities and founded on First Nations law, traditions and cultures. That would end the focus on polices and prisons and prioritise culturally safe access to support Aboriginal people need. It helped eradicate racism by placing power with Aboriginal communities instead of lobbies like the police union. A justice treaty must be negotiated by Aboriginal communities. It is not something for Yoorrook to decide, but the impetus for this negotiation sits with the Yoorrook Commission. The Commission must recommend a mechanism for transformational change in the criminal legal system. This naturally will take time, and much consideration and consultation will need to take place to ensure that a justice treaty is established with the best possible resources and interests. Whilst that is going on, there are urgent reforms that need to be implemented. To prevent further Aboriginal deaths in custody, the government needs to urgently reform the punitive bail system. Aboriginal women are the most incarcerated cohort in the world, and in Victoria, the punitive bail system is one of the key drivers of incarceration, and there should be no more Veronica Nelsons. Establish independent, culturally appropriate detention oversight. The Victorian Government cannot keep waiting for Commonwealth funding while Aboriginal people continue to die in Victorian prisons. Establish independent police oversight. Victoria Police must be accountable for racist and harmful policing, and they cannot do that themselves. Overhaul the prison healthcare system and ensure that Aboriginal people who are incarcerated have access to culturally safe healthcare delivered by Aboriginal community-controlled health organisations. The Ricky Dick recommendations clearly found that healthcare was one of the leading causes of Aboriginal deaths in custody. Those recommendations were handed down when I was 2. I'm now 35 and we're in the same situation. Similarly, there is a critical need for urgent reform in the child protection system. Victoria has the highest rate of Aboriginal children removal in Australia, and the child protection system simply does not work for Aboriginal families and communities. It does not create healing, it creates harm. Victoria has transferred some child protection powers to Aboriginal community-controlled organisations, but not enough. We need the child protection bureaucracy out of our kids' lives. New standalone child protection legislation for Aboriginal children would create a dedicated system that could deliver culturally safe legal support for every Aboriginal child, new protection orders that are tailored to Aboriginal children's need, and an end to the criminalisation of vulnerable children in residential care. Our communities know the truth about the origins of the legal system and its ongoing impact on Aboriginal communities across Victoria. We experience those truths every day. But this is not common knowledge in Victoria. The process of revealing, acknowledging the truth about our past and present has begun, but society has a long way to go, and you have a huge role to play in that. Yoorrook has far-reaching powers to unearth the truth about Victoria's legal system and how it needs to change. The potential of this truth-telling process is enormous, and we urge Yoorrook to use the full extent of its powers to tell the truth. I also take this opportunity to urge the Victorian Government and the Premier to commit to not just reform, but actual transformation. In doing this, they still need to implement those urgent reforms. Our communities demanded for generations that our justice system needs to be considered just. And as we've been saying for generations, no justice, no peace.
Thank you. Now, your opening statement has touched on many of the matters which are contained in your in the VAL's detailed submissions in relation to both child protection and the criminal justice system. And I'd like to ask you a few questions about your submissions and many of the areas you've touched on. And I will direct my questions to you, and if you want to redirect them to other members of the panel, then I'll leave that in your hands if that's okay.
Not a problem.
Firstly, I just for the purposes of the record, if you could just tell us a little bit about the Victorian Aboriginal Legal Service, its size, the services it provides.
Not a problem, love to. So the Victorian Aboriginal Legal Service has been around since 1973. Obviously next year is our 50th anniversary. We started off obviously very, very small and just delivering criminal legal service. And we've now expanded into the areas of family and child protection and family violence, as well as civil and human rights. Civil and human rights includes matters like tenancy, discrimination. We run an infringements clinic to try and address fines and the consequences they create for communities, as well as now we have our real way practice, which largely deals with criminal inquests regarding deaths in custody and police contact deaths, and also civil litigation resulting from those matters. Because we represent many parents, and there's obviously conflict rules around representation, we created an Aboriginal children's legal service called Ballit Nalu, which means strong voice. In its conception in 2017, it was delivering legal services to Aboriginal children in both the family and criminal division of the Children's Court of Victoria. And that was self-funded through VALS. When those funds ran out and we had to go to government, they refunded it, but only to provide criminal law service delivery. That's obviously very harmful and impactful for our crossover kids. We have 110 staff. We provide services statewide. Our largest practice is our criminal practice with 12 lawyers at this point. Our family practice has 5, Wirraway has 2, and Ballitnaloo has 5 now as well. We have CSOs based in 6 locations, and we also have family violence support workers to work with families experiencing or at risk of family violence. We also run Yoorrook, which is a women's transitional service for those exiting prison, which has just been fantastic and has had untold benefits for the women who've been able to participate. And we also run the VIPA program, which is where if Victoria Police see somebody who's at risk, so they might have been notified of a police situation, like such as a witness, or have been tangentially connected to a family violence incident, they'll go through that system and we'll link up with them and provide them referrals and assistance.
Thank you. And the criminal law service you provide is a 24-hour service?
Yes, so we have an on-call duty lawyer to provide advice 24 hours, 7 days a week through our CNS program, which does the welfare checks for Aboriginal people in custody.
And the client service officers, the CSOs, are they all Aboriginal people?
That's correct.
And so they're the first point of contact for your organisation when a person goes into custody?
No, the first point of contact is our CNS officers, our custody notification workers. They're also all Aboriginal and Australian Islander. And what happens is that once an Aboriginal person is taken into police custody, a notification automatically comes through to us. We then ring the police station to connect with the Aboriginal person and do the welfare checks to make sure they're okay and connect them to legal advice and assistance should they wish. If they have an alternative legal assistance provider, then we make sure to connect with them to give them the relevant information they need to do their job.
Thank you. Now, I want to first take you to the written submissions in relation to child protection.
Yes.
And first, I'd like to start at page 56 of your submissions, where you refer the Commission to Articles 3 and 4 of the United Nations Declaration on the Rights of Indigenous People in relation to the right to self-determination.
Yes.
The observation at the second paragraph on page 56 is that self-determination, and I'm assuming that it's self-determination in the sense that is referred to in the United Nations Declaration on the Rights of Indigenous People. Your submission says self-determination has not been realised in Victoria's child protection system. You see that submission?
Yes, I do.
And it goes on to say that the Victorian Government says that it's supporting the vision to increase Aboriginal self-determination in the child protection system, suggesting that it sees self-determination as some sort of spectrum. Would you like to just comment on your observation of the way in which self-determination is given voice in the child protection system in Victoria?
Yeah. So when you're talking about self-determination spectrum, certainly in the child protection system, our version is it's self-determination light. When you look at the handover of power and responsibilities to Aboriginal organisations, there's not enough resources to support that, but they're also not provided the same decision-making power as if they were the department, which for us means that it is not true self-determination.
Mm. And so you make a reference to Section 18 of the Children, Youth and Families Act and say that transfer or delegation of power is a gesture in the direction of self-determination in the child protection system, but falls far short of what genuine empowerment is. You clearly stand by that submission, but in saying that, you're saying that there's a lot more that needs to be done by the department and the government if it wishes to see true self-determination in its proper sense.
Correct. That self-determination would see a transfer of power and responsibility in decision-making.
And you've, on the same page, in talking about the power which is transferred under Section 18 of that Act, you note an article that was published in Indigenous X where a kinship carer, Sissy Austin, states, "The key facts here are that ACCOs are not making the life-altering decisions for our families. The Children's Court is. The children are not mandated to be in Aboriginal care. They're being case managed by an ACCO where they might not even get an Aboriginal worker, and in this case management must be in line with what has already been ordered by the courts." So that's that. If I suggest to you that that's a long way from self-determination, would you agree with that?
I would.
So in some of the analysis that follows in your submission, you point to things that indicate perhaps a failure to understand or a failure to observe the right to self-determination in its proper sense. One of those is poor consultation. And Commissioners, on page 57 at item 3.1, the submissions are available to be read. But the thrust of the submission in relation to the present methods of consultation is that the department tends to only consult with the Aboriginal Children's Forum.
Correct.
And in your view, that should be a minimum.
Correct.
And one of the concerns that you have is that the Aboriginal Children's Forum members are funded by the department. Is that correct?
That is correct.
So you don't say this explicitly, but is the inference that it's difficult for them to speak out against the department when they're the ones that are funding them?
Yes.
And then the point is made that other ACCOs such as VALS and Jura are not consulted by the department. That's routinely the case, is it?
That is routinely the case. Where we are consulted, it is literally at the last minute.
And given that that seems to be the part of the methodology of consultation of the department in terms of child protection matters, does that say anything about the intent of the department if it's not speaking to the bodies that have the legal expertise to comment in a thorough manner?
Yes, I think it suggests what anybody would take from that is that they don't want to hear contrary views. They don't want to hear views that go against their envisioning of what self-determination light is. Certainly, we've come up against this time and time again, and we have tried to develop close relationships with the department in order to kind of rectify that consultation deficit. We've tried to obtain membership to the ACF, but time and time again, those attempts are rejected. And I just wonder, Anna, do you have anything else to add to that?
I think you've pretty much covered it. Yeah, no, I don't have anything else to add on that particular point, no.
Thank you. At 3.2 of your submissions, which commences on the following page 58, Commissioners, you identify that the transfer of powers to Aboriginal agencies hasn't occurred in the way that it should do in order to give voice to principles of self-determination.
Yes.
In particular, you've identified that Section 18 of the Children, Youth and Families Act purports to achieve this, but only has the effect of transferring a limited amount of function and powers. And you go on to break down your submissions go on to break down the nature of the powers or functions that the Secretary might have into three categories. I wonder, is it possible to summarise for the Commissioners how the agency might better go about transferring its powers to support self-determination.
Sure, not a problem, and I'll hand over to Anna to do that.
Okay, thanks, Nerita. So what Val's proposes is that it would be far more effective if there was an Aboriginal specific act that is separate from the Children, Youth and Families Act, rather than trying to adapt the Children, Youth and Families Act, which is the current legislation that empowers the department to exercise its powers, rather than trying to adapt that act for the transfer of powers, that there should be a separate act that empowers the ACOs to exercise those powers in and of themselves in their own right, and in that way they would the numerous other issues that there are with the Act for Aboriginal families, but indeed for all families, but these seem to have a greater impact on Aboriginal families. Those changes could be made in the Act that's for Aboriginal children, and it could be drafted by not just in consultation at the last minute with Aboriginal community-controlled organisations, but it could actually be led and drafted by those organisations, and that would need to include Aboriginal legal services as the organisations that do have the legal expertise and the organisations that do represent fathers, mothers and children in those proceedings in the court.
And so...
Sorry, Tony, the only thing underpinning that, of course, would be the principles of, the distinct rights and responsibilities of Aboriginal children, because they're certainly not given voice to in the current regime.
Sorry, I missed that last part.
They're certainly not given impact in the current regime.
So on page 63, there is a recommendation from VALS that the Victorian Government should develop standalone child protection legislation for Aboriginal children and their families to enable the transfer of the complete set of child protection functions to ACOs and address systemic failings of existing legislation, policy and practice. And I understand from Ms Gibson's response that the current legislative arrangements are, in Val's view, beyond repair, and as they pertain to Aboriginal families and children, and the appropriate course would be to start with fresh standalone legislation. Is that the view?
Yeah, that's the view. There's a range of reasons for that view. The one that I just mentioned about enabling Aboriginal organisations to create their own court orders, as Nerita just said, incorporate international human rights standards for Aboriginal children and have the whole thing based on a human rights-based approach for Aboriginal children. But the other issue that it would resolve is the fact that the current scheme substitutes, when Section 18 is exercised and an ACO is authorised with those powers, the current Act refers to the Secretary. It doesn't refer to the ACO or the Principal Officer, who's the CEO of the ACO, who's authorised with those powers. And therefore, there's a whole range of powers and functions throughout that Act that refer to the Secretary, or indeed refer to third parties in relation to the Secretary, that are completely inadequate when an ACO is authorising those powers. The third party is not going to know, am I required to do this with the Secretary or with the ACO? It's just unfit for the purpose that it's designed to achieve.
And from years and years of our experience, the answer to the child protection crisis is not to put Aboriginal organisations in the shoes of the Department of Families and Fairness of Housing, is to design and transform a system that works for them, that is based on their cultures, on their philosophies, on their beliefs, and our inherent power to self-determine our futures.
Thank you. The question that arises to my mind is if there is to be standalone legislation designed, that would have to be with the support and imprimatur of the Minister, and the Minister would be taking advice from the department. Does that raise concerns for you in terms of how the government may engage in the preparation and creation of such standalone legislation?
Yes.
Is it the case that the legislation or draft legislation that you're talking about would need to be designed? I know Ms Gibson said designed or drafted by the community organisations. Is that the preferred mechanism, that it is firstly drafted in the community and then provided to the government, rather as a way of a form of negotiation, rather than the department consulting and trying to interpret what communities want?
Yes, that's correct.
I'm sorry I took so long to get there on that one. Of course, if the department were involved in the design and drafting of such legislation, would you have concerns that it would engage in that process in a way that served its own interests, the department's own interests?
If it didn't go with our preferential way of doing it?
So if the Minister asked the department to design the standalone legislation, would you have concerns about the department's?
Yes.
Because I asked that question because in the course of identifying the difficulties with the transfer of powers within the present structure in the Children, Youth and Families Act, you've identified a number of circumstances where the department takes a narrow interpretation of the provisions, which seems to be at odds with the intent of the part and the whole of the Act, in a way that, and I think the term self-serving might have been used in your submissions. So with that sort of history and that minimalist approach, is that something that would raise concerns if the department had too big a hand in the drafting of standalone legislation?
Yes.
Now, at 3.3 of your submissions on child protection, there's discussion about separation of department functions. I might read to you the first paragraph of that submission. The colonial context of the child protection system and the paternalism that has been a strong feature of it mean that many Aboriginal and Torres Strait Islander people are rightfully sceptical and fearful of the child protection system. Poor governance structures feed into those concerns. That submission goes on then to say, well, there needs to be a separation of functions within the department. But it's not explicit, but is that put on the basis that there's not standalone legislation? If we're stuck with the existing legislation, then there should be a separation of functions. Is that the case?
Yes.
Okay, and so can you just explain to the Commissioners what the separation of functions is that's proposed?
Yes, so certainly in 3.3, in paragraph 3, you'll see that we are trying, perhaps not as clearly as we could have, say that they shouldn't be drafting their own legislation and that function should be separated out. And we talk about the litigation functions of the child protection system being separated out. I know this has been explored by Queensland, I believe. There's, I think a New South Wales review also recommended that New South Wales follow that example, but unfortunately there's not much evidence on kind of what has resulted from that.
So in your submissions, you helpfully draw a contrast between the criminal justice litigation in Victoria and the child protection litigation in Victoria. and the separation of functions within the criminal justice sector. Is there any? Can you just expand on that a little bit for the commissioners and express any view as to why there should be a distinction between the two areas?
Council, can I just get straight in my mind what functions we're talking about, which need to be separated?
So
certainly is it okay if I answer?
Yes, please.
Certainly in 3.3 what we're talking about is that they shouldn't be responsible for drafting their own legislation because they do a very poor job at it. And the second is that we note that there have been developments in Queensland and New South Wales around also separating out the litigation function.
Yep.
So that is obviously when a protection application arises and that has to be actioned.
Yep, got it. Thanks.
And so you've drawn on those examples in Queensland and the developing example in New South Wales as being circumstances in which the litigation in respect of child protection has been separated from the operational aspects. Is there any reason why that can't be done in Victoria?
No, and I would urge the Yoorrook Commission to get some further information from those jurisdictions to see how that has actually eventuated, because you have more power than I do to get that.
And just going back to the drafting of legislation, in the third paragraph on page 63 under the heading 3.3, separation of department functions, the observation is made that there are clear conflicts of interest in this arrangement, and Vals believes that there have been occasions where child protection has drafted legislation that was solely in its own interest.
Yes.
Now, I want to take you now to 3.4. Commissioners, this is at page 64 of the submissions, part 3.4 of the submissions, where you talk about ineffective governance. Your submission is very critical of the Department of Family Fairness and Housing in relation to its internal governance.
Yes.
Of course, in your view, that's warranted.
Correct.
And one of the key aspects of that criticism, if I can put it this way, is the poor record keeping.
Yes.
Do you see record keeping as not only for its practical importance, but is it some marker of poor governance in your opinion?
Yes. And it's not only just poor record keeping, it's the continual change of ministers. I mean, there's been 5. There's been the machinery of government changes in terms of separating out functions and calling them by new names and establishing, committees, and then they fall down, and consultative mechanisms, and then they fall down. But the poor record keeping not only affects when we're representing children and families, but it also just affects, I believe, like their ability to do their job when they don't know where kids are or their address. Kind of feels like that's crucial information.
Yes, and you cite the Auditor General's report for 2022 that the department did not have a primary address for 462 children in its care.
Yes, if I didn't have an address for my child, Tony, I think that I would be in trouble.
And of those, or perhaps another 171 were recorded as address unknown.
Mm-hmm.
I mean, are those figures shocking to Vals, or they don't come as any surprise?
They're not shocking because they don't come as a surprise. It's certainly disheartening and tragic. But through our CNS, we also obviously pick up children who were squatted from placement. So we're quite aware of the fact that the Department of Families, Fairness and Housing often don't know where children in their care are.
Should the public be concerned about that? Or parents of those children?
Yes. Anybody who understands the responsibility of having a child and caring for a child should be concerned at those facts.
And there have been many reports over recent years about this particular problem in respect of record keeping, but many other problems. And these failings haven't been addressed. Do you have any view as to how that happens?
Perhaps part of it is, report fatigue, that there are so many reports, there are so many recommendations, and there is limited workforce to implement all those, but also there's not effective oversight of implementation of those recommendations. So, who's making sure they're getting done? I think that's the reason why you see that not addressed.
I just want to take you to part 3.5 of your submissions now in relation to data and accountability. The observation is made in the submissions that there is limited availability of data. It's not only limited availability but limited collection or limited appropriate collection of data.
Yes.
And the contrast is made with the criminal justice sector.
Yes.
And is it your evidence that there's better collection of data in the criminal justice sector than in the child protection sector?
There is slightly better data collection in the criminal justice system as compared to the child protection system.
And your submissions make this out fairly clearly, but just for the purposes of the commissioners, the absence of appropriately collected and publicly available data has real effects in terms of transparency and accountability?
Yes.
Does it also have effect in terms of observing trends and management of work and ensuring that the agency is able to fulfill its role?
Correct.
In respect of now part 3.6, Commissioners, on page 66.
Yes.
You there address oversight measures in the child protection system and make the observation that current oversight measures of the child protection system in Victoria have been ineffective at driving improvements. And this goes to your point a few moments ago about perhaps report fatigue. And is it fair to say that your submission on this point makes the point that there are many reports being undertaken and that the action following the reports is limited, if I can put it in a very bland way of putting it. But so you've recommended an independent detention inspector.
Closed environments.
Sorry?
For closed environments.
That's right. And you're saying, your submission says that, if I'm correct, that come January 2023, the Victorian government will be in a position of having failed to met the obligation with respect to the optional protocol on the Convention Against Torture.
Yes, their second deadline.
Second deadline. Yes. And
sorry, excuse me, Councillor, can you just repeat what it is that Victorian government is missing, will be missing again in January?
Establishing a national preventative mechanism, also known as an NPN, under the option protocol for the Convention Against Torture and Inhumane and Degrading Treatment.
So, your submissions have been or are quite thorough, and notwithstanding you called for a standalone legislation and a new system, you've offered some suggestions as to how that current system can be improved, including recommendations regarding the replacement of the current system of protection orders with a new care and protection order.
Yes.
Commissioners, at page 41 of the submission, you'll see recommendation 17. And that recommendation provides that, and I'm not going to read the whole of the recommendation, but the chapeau reads, legislation should be amended to replace the family reunification orders, care by secretary orders and long-term care orders for Aboriginal children with a new care and protection order. And then it sets out the terms of the care and protection order and the conditions that may be made against that order. Can you explain the reasoning behind this change to the system of orders?
Certainly this change has been a result of what we see as deficiencies in the current system, and what we've tried to do is come up with a proposed order that would increase the power of the court to attach appropriate conditions in the order, because through the permanency amendments that was all but eradicated. Also ensuring that you're facilitating contact with children and making best interests for Aboriginal children without that arbitrary oversight. But Anna can expand on it further.
The idea behind the new order and replacing those existing orders is very much to address the concern that's been raised in many of the hearings that the Commission's already, many of the witnesses that have already spoken to the Commission about the permanency amendments. Many of the witnesses referred to these as the 2-year time limit, and it's actually not the time limit itself that is the problem. It's what happens after that time limit expires. And what happens is there's only 3 orders available to the court to make, and those 3 orders have very little, the court has very little power to make conditions or control what those orders do. It gives all the power to the department once any of those orders are made. So 2 of the orders are transfer sole parental responsibility to the department. One will exist, that one order will stay in place until the child turns 18. The other will stay in place for 2 years. And the significance of the duration of the order is that the duration of the order is the primary mechanism that enables cases to come back to court so that there will be court oversight. And with legal aid funding, that's when parents and children have a legal representative to argue their case in court. So if the order expires when the child's 18, that mechanism is not there. Similarly, if it's 2 years, whilst 2 years is shorter than 18 in most instances, it's still a long time where there's no conditions for contact with parents or family, no conditions to support parents to access services, to address the issues that they're having in their lives that have caused child protection to be involved in the first place. So there's those 2 orders, and the other order is the permanent care order. And on that order, the parental responsibility is transferred to the carer, and the department then ceases to be involved altogether. So at that point, I think the Commission's already heard from a witness, I'm not sure who it was, but someone I remember said that once that happens, then it's really in the hands of that carer as to whether that child will ever see their family again or have any connection to their culture. Despite there being some provision for that to happen, it's really left in the hands of the carer.
If I understand the Val's submission correctly, it's not suggesting that the amendments in relation to this suite of orders were intended to have the effect that they've had, but rather that the resources haven't been made available or aren't available in order to ensure that the proper assessments and work is done prior to the engagement of permanency orders. Or have I misunderstood?
I'm not sure I properly understand your question, but I would say that, in my view, that the way those permanency amendments were introduced, There's a lot of, there's many sections of the Act that refer to, make reference to the purpose of them at different points in the sections about the orders themselves, but also in the case planning section about permanency objectives. And there's also, there were also 2 additional best interest principles added into the section 10, which is right at the beginning, which is supposed to inform all decision making. Anyway, these multiple sections of the Act that were added all talk about ensuring stability for the child. So the goal is to, if the child cannot be reunified within, it's really actually 12 months that it's geared towards. The 2-year thing is meant to be an exceptional situation. It's the Act is guided towards the child being able to be reunified within 12 months of being out of the parent's care. And if that can't be achieved in that time, then the move is to find a stable placement and in doing so, removing and severing all contact with family. So that's the sort of stated intention in the legislation. But you could also say that in
that its practical application has had a disastrous effect on Aboriginal communities. And in fact, during the consultation process for those permanency amendments, the Department of Family Affairs and Housing, which was then called the Department of Human Services, I believe in that iteration, was warned that if they proceeded, the practical effect of those would be disastrous to our communities, and that's what happened.
Yes, okay, thank you. Your submission does point to the disjunct between the permanency objectives and the unacceptable risk test. And I understand that to be this something that you've just spoken about in terms of the stability versus the desire to remain with the family. Now, one moment.
Councillor, can I just, while you're doing that, can I just ask Ms Gibson a question? If that's, you just talked about the stability and the permanency, and 12 months is the objective. And you talked in your opening statement about women going into prison at a higher rate. What happens if an Aboriginal woman's incarcerated for more than 12 months? What would that mean for the Act?
The Act doesn't accommodate that. That would just be a situation where the child isn't able to be reunified in the timeframe, the legislated timeframe, because she's incarcerated.
So could that be a possibility of that stability going into permanency? The stability of, so that could go into a permanency with a carer, for instance?
It should be noted, though, that just because the objective is to move away from the parent after the 12 months or the 2 years in the exceptional situation, doesn't necessarily mean that there's this permanent placement just there waiting for this child. In most instances, the child then goes on to a care by secretary order. The secretary is the child's guardian. And in many cases, especially for adolescent children, they will move from placement to placement to placement to placement. And the most stable, the most likely placement that would be provide stability would be with the child's parent. But there's no direction to look at the child's parent.
So there's no accountability for the department for when they bring in provisions based on the promise of stability to actually deliver that stability?
No.
Thank you. I just want to ask you some questions now about the Aboriginal Child Specialist Advice and Support Service. That's access. That's covered at page 24 and onwards. Submission. I understand your submissions to highlight that access advice is not being accessed, or when it is being accessed, not being used in the way it appears to have been intended to have been used. Just for the Commissioner's purposes, could you explain the role that Vals understands Access should have?
So the role of Access is it's a funded program. So the department funds an Aboriginal community controlled organisation to provide them with there's an obligation for the department to consult with the ACO on every significant decision for an Aboriginal child, and they have program requirements that list a whole range of decisions that they consider to be significant decisions, but it also says this is not an exclusive, exhaustive list of decisions, and that, so any significant decision should be consulted with an Aboriginal organisation. The goal or the intent is to ensure that the department's decision-making is taking into consideration cultural issues, and it's also stated in Section 12 of the Act to be a mechanism of self-determination. So does that answer your question about the purpose?
Thank you. And so there are a number of problems with that model of support that you've noted in your submissions. Can you just speak about those issues?
I think one of the main problems is that we see at the court, obviously, what our role is as lawyers. So most of our involvement in families' lives is at the court stage. But the department should be consulting at all stages, not just at the court stage. But what I have most experience with is seeing it play out at the court stage. And at the court stage, the decisions that they're consulting on have legal implications. Like, for example, what order the department is going to seek and ask the court to make. That's something that they would need to consult with the ACO about. And the best example to illustrate the issue is that if the person from the ACO providing the advice is not aware of the different orders and the technical aspects of different orders, and I must say that the legislation is not drafted well and has multiple amendments in it, so it's complicated for anyone to understand. So I'm not trying to suggest that the people providing advice are, incompetent, but they're not lawyers, and they're providing advice on a legal outcome that has real consequences for the children and families who it impacts. And so the best example I can give is one of the orders is called a family reunification order, and a ACO may endorse that decision based on the fact that they believe that in seeking that order, the child will be reunified to the family when that order's made. And in most instances, they're never reunified on that order. They're certainly not reunified on the day the order's made. And the lawyers representing parents or children in that matter might be actually seeking for either a family preservation order, which would mean the child would be at home with the parent, or in some cases maybe they might say that an order is not even needed. And instead they're going to this order that's an out-of-home care order.
So the ACO workers are being asked to give advice about the child's rights, in fact.
Yes, they are, yeah.
Without legal training.
Yes.
And without access to legal advice.
Yeah, and I should add that on top of, that is the biggest concern that I've just illustrated, but there's a whole range of concerns with it. There's concerns like incorrect information being provided so in this instance, they've been told the correct information. We're seeking a family reunification order. The ACO doesn't understand what that fully means for the child. But there's instances where Child Protection will give misleading information to the ACO or leave out information to try and, get the answer that they want from the ACO. Or there's also instances where, due to under-resourcing and funding, there is no ACO available to provide the advice for the decision. The information is also relayed inaccurately to the court. The court is forever, the magistrates in the court are regularly voicing their frustrations about this situation where they have to rely on the child protection worker to tell them what the advice is of the ACO.
You make the observation that in the submissions that advice is sometimes not sought at all.
Oh, yeah, correct. Sorry, I should have used that example as well. Yeah.
In relation to many of the decisions.
Many, yeah, that's frequent. I should have said that.
And if I've understood the submission correctly, it's also your submission that ACOs are involved at often at a very late stage and asked to give advice under extreme time pressures.
That's correct. Yeah.
And so that doesn't allow them to consider the matter properly or give considered advice.
Yes, that's correct.
It sounds as though there are many issues with that system.
Yes.
Can I just clarify? So is there anything there that tells them that they must seek advice?
It is in the legislation, but it's drafted in a very vague way. So it's Section 12 and Section 16 of the Act. So Section 12 talks about the need to consult with Aboriginal organisations, and there's a number of subsections and that then relate to different functions of the department. One is about Aboriginal family-led decision-making. One is about this function that we're talking about now. And then just consulting generally with Aboriginal family members. But it's not expressed in a very clear way that really specifies what the responsibility is. Section 16 refers to the Secretary's responsibility to, can't remember the exact wording, but to follow protocols with Aboriginal organisations. And so there is a protocol that details this function that we're talking about here and spells out what the decisions are to be consulted on. So the detail is in the protocol, not in the Act. But they also have program requirements and child protection manual that does provide all the detail.
So what do they tell magistrates if they haven't done any consultation? How do they justify that they haven't completed that part of their obligations?
No comment on that. Any number of responses.
Do you say that it's a matter about which the Commission might use some of its powers to inspect some of the files and draw some conclusions?
Yes, please.
There is, just before we leave this point, you've also made the comment that there's insufficient training for the access officers.
Yes.
Do you say that there should be some legal component to their training if they're required to make decisions in this way? And is VALS or Jura in a position to give that sort of training, do you think? Or
Yes, and yes.
Okay. Clearly, you've given a lot of thought to this area and how it's failing Aboriginal children and families. Do you have any views as to what the drivers of this system failure is?
I do think a big factor also behind the permanency amendments and a range of the issues that have been raised by us as well as other witnesses to the Commission is the under-resourced nature of the workforce and that they are stretched, like they're definitely under pressure, the child protection workforce, and that's obviously not an excuse for Aboriginal children ending up in the way that we're seeing the rates of removal and so forth, but it has to be acknowledged that has to be a driving factor in the way the department develops its policy, which reduces anything that involves labour-intensive, each time a child protection worker has to go to court, that's labour-intensive, so let's reduce the court oversight. Anytime they have to have contact with a parent and it needs to be supervised, requires,
But I mean, even at earlier points, there are drivers. Our clients are often remanded for petty offences like shoplifting. That then takes them out of the home, and then their children end up in care. They try to flee a family violence situation, but there's no adequate housing, so their children are taken off them. I mean, all of these things just don't work. There are not enough social supports, there's not enough housing. But we are also predicated on a system that doesn't understand Aboriginal ways of being and knowing, and instead enforces a non-Aboriginal conception of how you raise your children and how things are supposed to be, which is completely at odds with our culture and our traditions. If I can just use a personal example, non-Aboriginal conceptions of families are often nuclear, mum and dad or mum and child, or those kind of variations. But I grew up, my dad unfortunately passed when I was quite small, but I had my mum and I had my grandmother and my great aunt who was like my other grandmother. That was my family unit. If my mum wasn't there, either grandmother stood in the shoes of my mother. And those are not things that are well understood, and that's often why child protection become involved and actually did at one point. And it's unfair. And that's why we talk about a transformed system, because it's not just saying, let's throw all the social supports in, it's saying we actually need to address the racism within our structures and our institutions and our legislation to create a system that works for our communities.
Thank you. So there is structural racism within the system, but in relation to the access issue, do I understand that you're saying that in part the lack of resources and the very the overload of work for the workers has an effect, and do you have any view as to whether that effect causes them to cut corners in their work?
I'm sure they're forced to cut corners all the time. I'm sure that they have to. But I do want to reiterate, though, what Narita has said, that the role of racism as well. So where there's corners to be cut, which corners do they decide to cut?
That was the next point I was coming to. I was going to say that where people are cutting corners, they tend to rely upon the stereotypes and biases, whether they're conscious or unconscious. And is it an observation? Is there an observation you can make about whether those biases tend to come to the fore in the child protection space, where it is overworked and overloaded?
Yeah, I believe it does. Yeah.
It's obvious it does.
Thank you. Now, I just want to ask you a couple of questions about what are called the crossover kids, the kids who are in both the child protection system and the criminal justice system, and that's at part 4 of the submissions, Commissioners, page 67. One of the I mean, you talk in your submissions about the really quite unacceptable ratio of children who are in the criminal justice system who have come from the child protection system, and how much or how little the child protection system is able to do to protect those children from the criminal justice system. One of the factors you talk to is the criminalisation of children in residential care.
Yes.
And that is a big issue.
Undoubtedly.
And there's a role that police play in respect of the criminalisation of children in care.
Of course.
Is it the case that VALS has observed a an over-readiness of police to charge children who are in residential care?
Yes, and can we just go through a case example?
We've got a case example here on page 71, case study for M.
Yes.
Is it the one?
Yes, that's the one.
I'd be grateful if you did.
Perfect. So M was an Aboriginal child who was placed in residential care at age 11 and has been placed in at least 12 different care facilities since that time. During their time in residential care, their behaviours indicated serious mental health and disability issues, including self-harm and suicidal tendencies. Despite that, there's no consistent mental health support, nor consistent schooling or cultural support. His contact with police escalated throughout their time in residential care, and the carers often contacted police for behavioural management matters. When they contact police, those police officers respond immediately with arrest rather than summons or de-escalation, and as a result, they've been repeatedly detained in police stations and at Parkville. This is not just, a matter of 11 or 12 incidences or 20 or 30 or 40 or 50. M has spent months on remand despite never being sentenced to a term of imprisonment. M's carers have contacted police for behaviour, including stealing household items, throwing items around their residential care unit and assaulting carers. They've also attended in the middle of the night to conduct checks on them. When police attend, instead of engaging in de-escalation, he's violently arrested and subsequently charged with assault police and resist arrest. In most instances, charges relating to the original behaviour are dropped. The only charges that remain are the police offences of resist arrest and assault police. He's also been targeted by police and has been violently arrested in public for reasons including to check whether they have warrants on public transport offences. The arrests are often highly violent and have led to sustaining physical, serious and mental injuries and being hospitalised. And they've often used abusive and humiliating language. And now M has significant trauma surrounding police, which impacts their interactions with police. Underpinning all of these situations was that there was a framework to reduce criminalisation of young people in residential care operating that time. It simply wasn't implemented until this matter came to our attention, and we then brought that framework to their attention despite it being their framework. And Sarah, do you want to expand on?
Just to say that there is, in 2020, the Victorian government published its framework to reduce the criminalisation of young people in residential care. Both the department and Victoria Police are signatories to that framework, and these instances in regard to M all occurred after the framework has come into place. And what we see is carers still contacting police for behavioural issues, and Victoria Police proceeding immediately with arrest and highly violent arrests. And also to say that none of these individuals involved in M's case appear to have any knowledge or understanding of what the framework entails. The framework puts in place very specific instructions for police and for the department to not proceed with arrest as a matter of first resort for police, for carers not to contact police for behavioural management issues, but instead to engage in de-escalation. And while the framework is a positive document and looks great on paper, there's absolutely no implementation and no one on the ground seems to be applying it. And it seems to have been taken as a broad, seems to be seen by both the department and Victoria Police as some pie in the sky objective that they're working towards at some stage. They're now talking about training that is being rolled out, but this framework's been in place since 2020, and there's absolutely no oversight of it. There's no evidence that we've seen that there has been training delivered to Victoria Police members on the ground or to carers on the ground. And, we only come into contact with these kids after they've been charged with criminal offences at a very late stage, and then we can intervene on behalf of them. But there are criminal charges that are already on foot, and the violence caused by the policing has already taken place.
And that commitment to training only comes after months and months of advocacy of our service and continual engagement with all of these bodies to try and get something off the ground. And there seems to be there seems to be this practice of coming up with these beautifully phrased documents and vision statements, but then not actually doing the work to implement them and then oversight it. And it's iterative of, my whole legal career. I'm sure many others who have longer careers can say the same thing. And each and every time when you draw attention to the harm that has been caused, it's, well, that's just too bad. There's no ownership of the harm, no commitment to engage in a restorative practice, so that, say, if M was a victim of crime, M's not going to go to the police and report it because he's going to be afraid that he will be hurt. And there's no commitment on their end to say, well, let's restore that relationship because we don't want M to be in that position. There is nothing. And in fact, all it is we'll just blame individual officers or move it across, or, label our service as dogmatic and, rather unforgiving, and perhaps that's an accurate assessment in some parts. But these children are being criminalised just by being in care. This is no fault of their own, and often they're in care again, situations that are out of their control, but they're painted with a brush that they must be accountable for that and they can be criminalised. And these are the same kids who then end up trapped in that adult system, and their children will end up in the same place if we don't do something to disrupt the narrative and the structures now.
Even without the framework, the fact that the police are arriving at a scene and then charging young people with offences, then dropping the original charges but proceeding with the police contact charges, it seems to be an offensive way of dealing with young people. Would you agree with that proposition?
100%.
Could I add as well that there is a legislative provision, Section 345 of the Children, Youth and Families Act, which states that police should presume that children should be proceeded with by way of summons rather than arrest. And across the board, we see that provision completely not being applied. There's no case law on that provision, and it doesn't seem to, police don't seem to be aware of it.
Thank you. I might draw the Commissioner's attentions to the case study in relation to R at page 73 and the case study in relation to CH at page 75. The case study at page 75 deals with missed opportunities in the child protection system, and in particular a failure to diagnose mental health conditions that a young person had been suffering for a long period of time whilst in care. It had never been picked up and clearly affected and had a role in the young person's contact with the police, the criminal justice system.
Could you give me that reference again, please?
It's page 75 and it's case study CH. The recommendations of VALS in respect of this area are contained on page 74 in recommendations 27 through 35. The submissions speak for themselves, Commissioners. In the interest of time, I propose to move on to the criminal justice submissions, but I will point out that at Annexure A to the child protection submissions, the VALS are recommending to Yoorrook that it should invite or compel following people to give evidence. From the government, they're suggesting that the Minister for Child Protection, the Secretary, Department for Families, Fairness and Housing, and the Deputy Secretary with responsibility for Child Protection, Department of Families, Fairness and Housing should be called. And from the police, the Deputy Commissioner for Victoria Police with responsibility for implementation of the framework to reduce criminalisation of young people in residential care, and the officer in charge, Ringwood Police Station. Finally, with respect to the Community and Public Sector Union, officials with representative responsibility for child protection practitioners. Now, I'm assuming that everybody's happy to continue on.
Yes.
If there's a need for a break, please let me know. But I wish to continue on with the criminal justice submissions now. This is a separate document, Commissioners, and I understand that you have a copy of the criminal justice submissions, November 22. Ms. Waite, you spoke in your opening about a justice treaty, and that also formed the subject of a press release from VALS today.
Yes.
And the justice treaty, I understand, is seen by VALS as a mechanism by which the right to self-determination can be more fully realised in Victoria for Aboriginal people?
Yes.
Now, at page 27 of these submissions in relation to criminal justice, at the bottom of page 27, the discussion commences in relation to a justice treaty under the heading Self-Determined Solutions for Aboriginal Communities. The submissions talk about decision-making and diversion opportunities in a general sense. Can you just speak generally about how a justice treaty might operate or how it might be brought into existence in Victoria?
So our envisioning of a justice treaty was really based on seeing Yoorrook and the current treaty framework as an opportunity to create some transformational radical change, to build a system that embodies self-determination and one that creates a system that's designed and delivered by Aboriginal communities, that's grounded on our holistic and meaningful concepts of justice. There were early attempts of this in what you see in terms of the Koori courts, and certainly what you see in Aboriginal cautioning projects and Aboriginal diversion pilots. But again, there's a very limited role for our participation and decision-making. Everything is still in the hands of the authorities. And what we're trying to move people across to is thinking that, well, let's design a system that really embodies self-determination and really transfers that decision-making and resources back into the hands of First Peoples, just restoring our original position on this land. And also one that, the current system is so focused on risk and deficit rather than looking at strengths and opportunities. And we've had over 200 years of this justice system so far, and I'm struggling to really see what's been achieved and under this risk and deficit approach. And all the evidence suggests that if you take a strengths-based approach, you have a real chance of making sure that you're not building new prisons because you need to house more people, that you're actually being able to engage in providing resources at that earlier stage. People have the chance to have successful lives. Our parents have the opportunity to create, generational wealth and privilege and being able to engage in education and employment, and a society where people like me aren't an exception, they're the rule. That's really kind of the envisioning of it. And I know these are very broad statements, and the honest truth is that as an organisation, we've had very little capacity to really put out down what the nuts and bolts are. And I do think that part of that is because we have to do that with community. We can't just say, this is what it should be from our perspective. That's not self-determination.
In trying to envision what it might look like and how it might be achieved, you do look to the processes happening internationally for other
Yes.
First Nations.
Yes.
And you've referred to some of that on the bottom of page 28 of your submission. Would you just like to speak to a little to what your understanding of what's happening in other like jurisdictions?
Of course, would love to. So in New Zealand, there's been partnerships created with Maori communities, and those partnerships are based on existing treaties that have been in place for quite some time. But what those partnerships are creating is a real transfer of responsibility and control, and that's also seen in the legislative framework, which formally embeds that policy to implement self-determined approaches, but also acknowledges Maori law, which is what they call the right way, and has led to partnerships in terms of family conferencing, remand homes, rangatigi courts, Kapiti youth support, and all of these have had fantastic outcomes because they're based on principles of their local laws and customs, and really also don't just look at the individual before them, but look at the family. And the family over there is broader than just the nuclear family. So it means anybody who is important to that person, and really seeks to make sure that that change can be created for all, and also engaging in restorative practices where there has been wrong committed. So making sure there is that chance to restore those relationships and repair that wrong, so that your spirit can be well. And it's just, it's had some amazing outcomes. And if the Commission has the time, I would really urge you to call upon those New Zealand experts to really talk about what those responses are.
And is it your observation that those New Zealand examples operate in a positive and restorative therapeutic space as opposed to a deficit and a punitive space?
Yes, everything is done from a strengths-based approach. They don't do it from a deficit or risk viewpoint, and they don't have strict criteria in terms of time and resources. It is all about looking at the person, their family, and then dedicating those necessary resources and time to do that work. But also making sure that at each and every stage, culture and tradition is at the fore. And that goes from the very point of welcoming the person into the process to at the end where you engage in that soft transition out.
Thank you. And then at page 29 of the submission, you list out in the dot points under the first paragraph areas that may be included in a justice treaty. Mm-hmm. And there's some of the areas about which you've addressed in the submissions as areas of concern, but they involve communities being involved in decisions regarding cautioning, diversion and supervision of diversion plans, Aboriginal supervision of community-based sentences for in particular for low-level offences, Aboriginal-led body for investigation of Aboriginal deaths in custody and police contact deaths, expanding the Koori Court's jurisdiction to the pre-resolution stage, including bail and diversion, and expanding the role of elders and respected persons in Koori Courts, and also Aboriginal pre- and post-release support for Aboriginal people transitioning out of prisoners and youth justice centres.
Yes, and connected to that also is our earlier commentary on looking at an Aboriginal Social Justice Commissioner, but also, importantly, looking at requiring that where legislation is to be introduced, that its impact on Aboriginal people and communities be investigated. And if that is going to be a negative impact, then the legislation has to change. And this operates in a different way in the Charter of Human Rights and Responsibilities when looking at statements of compatibility. But the Aboriginal impact assessments sort of go one step beyond in terms of monitoring and also looking at making sure that those assessments are done independently of government by Aboriginal people and communities.
Is there anything along the sort of same shape as an Aboriginal impact assessment done currently with any of this legislation in the criminal justice or the child protection space?
No, this is an entirely new concept.
Now, we'll have some opportunity before we finish to discuss some of those issues that you've said might be included in a justice treaty. One of the other matters that you've dealt with in your submission is the transfer of power, control, data and resources to Aboriginal communities to develop and implement an Aboriginal justice system. Clearly, those are the elements that would make up an effective transfer of control.
Yes.
And it's important to note that not only is power and control suggested to be transferred, but also data.
Yes.
Can I just ask you to comment on how important it is that the data be transferred as well?
So data is a key driver of narratives about Aboriginal people and decision-making on policy. And in order to make evidence-based policy, you need access to data. So you can identify trends, you can identify issues, and you have a clear picture of what is going on.
And of course, the resources, you suggest that the resources need to be transferred as well. Are these all matters that ought to be or could be negotiated within the parameters of a justice treaty?
Yes.
In your submissions, you've also identified the impact of cross-cutting issues within the current system. The two cross-cutting issues that you've particularly addressed are racism, and if, Commissioners, you turn to page 30 of the written submissions on criminal justice, you'll see at paragraph 2.2 and following, there's some discussion of racism in the Victorian context. We have discussed this generally, and also in respect of the application of the child protection laws. In the criminal justice setting, are there particular observations you want to make about how racism affects the delivery of that system?
Sure. So racism for us is systemic in all parts of the criminal legal system. Laws, policies, institutions operate to produce discriminatory outcomes for Aboriginal people, and this is never remedied despite decades of advocacy and even prior warning. Racism is also particularly prevalent in Victoria Police, both in the actions of the individual officers and the systemic racism that pervades police practice. There are explicit instances of racism, like the denial of people's Aboriginality, repeated arrests of Aboriginal children who should be given a caution or a summons, and a shocking use of excessive force and racial abuse against Aboriginal people. There is systemic racism in the way that we're constantly overrepresented in police searches, move-on orders and arrests for public order offences like public intoxication, which in the last year has seen rates increase in Mildura by 100%. And it goes beyond police. It's in every part of society. It's from child protection to housing to employment. Aboriginal people are constantly marginalised by Victoria's social system. There isn't one Aboriginal person who hasn't experienced racism in all its forms. It's everywhere. I don't know much more I can say on it.
But with the understanding that it is everywhere, how then do you operate a legal system which delivers fairness to Aboriginal people?
I think my contention is fairly clear in looking at creating the justice treaties that that the justice system as it stands there is no justice for Aboriginal people within it, and it is not fair and equitable because it is based on a colonial past that is racist, but also a contemporaneous maintaining of structural racism and bias.
The second point that you raise is in respect of the lack of accountability of the police, in particular, as a cross-cutting issue. Can you just speak to that, please?
Which issue in relation to Victoria Police? Just there are a few.
Sorry?
Which issue in relation to Vicpol?
The lack of accountability, sorry.
Well, in terms of accountability, there isn't any for Victoria Police. At the moment, they investigate themselves. There's been a number of reports by IBAC and the Auditor General and the commissions very clearly showing that when a police complaint is made through IBAC, in the vast majority of circumstances, it's handed back to Victoria Police for investigation. And there are very poor outcomes for Aboriginal people in that space. Even when an Aboriginal person dies as a result of a police contact during the coronial process, it is Victoria Police that is doing the investigation of that death, which in itself just a direct conflict. And as VALS has done a lot of advocacy around independent police oversight, and because of the issues of policing in our community, the lack of independence, we had to create the Yoorrook unit in order to facilitate those numbers of complaints. And
I missed that key word. Created the
Yoorrook unit.
Oh yes, Yoorrook
Yes.
unit. Thank you.
Just in order to bring these egregious cases to the attention and also be able to provide Aboriginal people with a way to air their complaints against police and its institutions and arms.
Is it possible to have a system, a legal criminal justice system that delivers fairness to, or is applied in a manner that's fair to First Nations people, where there is no proper oversight of police conduct?
No, not at all.
Now, in terms of urgent or some priority reforms within the existing system, one of the matters that you point to in your submissions is the urgent need for bail reform.
Yes.
And Commissioners, this is at page 47 of the submissions. Um, 46 into 47, and then there's some draft recommendations on page 48.
Yes.
Are you able to speak to the recommendations regarding bail reform?
Yes. Over 30 years ago, Rika Dick recommended that government should revise any criteria which inappropriately restricts the granting of bail to Aboriginal people, and that prison must only be used as a sanction of last resort. Instead of doing this, we've done exactly the opposite and created more punitive bail laws and regimes, which have seen remand rates grow exponentially for our people, and particularly for Aboriginal women since the 2018 changes. And sadly, has also cost our community their lives, particularly if you look at the case of Veronica Nelson, who was a proud Gunditjmara, Dadasharong and Wiradjuri and Yoorrook woman who died in DPFC only 3 days after being arrested and refused bail for shoplifting offences. Uncle Percy says it best. He says Veronica shouldn't have been in prison and she shouldn't have died, and that he wants to know what happens. He wants to know what happened, and he wants somebody to be held accountable. But the sad fact is that every time we introduce changes to the bail regime, they are punitive and they discriminate against Aboriginal people each and every time. And much to do with that is the law and order approach and the influence of Victoria Police and the police union. And certainly what we're asking you to do is really urge the Victorian government to turn this around, to repeal the exceptional circumstances test, to repeal all 3 bail offences, to amend the unacceptable risk test so that bail must not be refused if there is a risk that the applicant will commit an offence whilst on bail, only if there is a risk that they will commit a violent offence, amend the new facts and circumstances test, and require bail decision makers who are judicial officers to articulate the matters taken into account with reference to subsection 3A and 3AAA of the Bail Act and the reasons for any refusal to grant application for bail made by an Aboriginal person. These reforms cannot wait. They must be done as soon as possible. I've given you the most disastrous outcome in Veronica Nelson, but there each and every day, on average, we have 35 Aboriginal people arrested in Victoria. Every one of them is at risk of this similar outcome. And often enough, we're talking about petty offences, shoplifting, drug possession. And often these individuals are in the most worst circumstances. They're homeless. They're suffering from mental health and disability. There's no housing for them. There's no supports. And instead of providing that, we criminalise them and then we lock them up for our failures. It's no longer acceptable.
And the government is aware of Val's position in respect of the reform of the bail law?
They don't have a choice not to be, every chance we get.
Are you seeing any movement?
No.
And do you put that down to the matters you've already mentioned, the influence of the police union and
Correct.
the service?
Yes.
There are any other factors?
Yes, I think I've mentioned earlier the law and order debate, but I also think that racism plays a clear role in why these changes haven't been made, because they see that Aboriginal people apparently have all these untold benefits and rewards that I've never seen, but apparently it's just giving them one more thing. What I think is also frustrating is that whenever there is reporting on this issue, often I don't think it's very clear to your average citizen what the problem is and how it can be fixed and how that doesn't jeopardise community safety. I think we've also warped community safety into something that it does not mean and not looked at ways of, redefining that for community and talking to them through a strengths-based view rather than a deficit view. We keep telling them that they're in need of protection without realising that they can protect themselves and they can engage in restorative processes, but often enough, the people who they need protection from are those who are shoplifting a can of Coke, who, are sleeping rough. And, public order offences are a key thing that often enough, particularly for our homeless community, those with mental health, those with disability, public order offences and drug possession and shoplifting are things that are regularly engaged in. And these are all considered very low-level crimes, but it will still put them in a position where they have to show exceptional circumstances.
There's currently there's no threshold of the sort of seriousness of the crime that would be affected by it.
Post 2018, what we did is we basically brought 100 offences into exceptional circumstances rather than the strict test it was before. And King can certainly elaborate on that further.
Yeah, so and not only that, but would they also then compound if that offence is committed whilst they're on bail, and that can be a low-level offence, such as shoplift or possess drug, and that also can catapult them into having to demonstrate exceptional circumstances. So a situation could be where someone is on bail for a shop theft, then commits another shop theft, and then they've breached their bail and they're picked up again and they're possessing a small amount of cannabis, personal use. They'll then be put in the exceptional circumstances test, where then basically and the presumption is against bail, and to get bail they need to achieve the same threshold as what would previously apply to people who alleged crimes of murder, treason, the more and definitely the high-level drug trafficking offences. So that's quite a lot of people, what we'd call really low-level offending that would never, ever attract a term of imprisonment, then finding that they're doing time in prison for these sort of offences.
So you wouldn't have to repeal the Bail Act, you just have to amend it to exclude these petty offences and restrict it to crimes that actually have a serious law and order impact on the community?
There could be some, I would say some very simple changes to the Bail Act that would definitely go a long way to fix this problem.
And our recommendations don't say repeal the Bail Act, they say amend it. And I think it's also important to note that children have to meet the same bail test as adults.
And we've heard evidence about over-policing of Aboriginal people.
Yes.
When you combine over-policing with a quite aggressive bail regime, that has a compounding effect.
Yes.
Yeah.
So that it's possible that an Aboriginal person might be on bail for some offence and then be picked up for something else, which they've come to the police attention for just because they're an Aboriginal person.
It's every day. It's playing out in the magistrates' court this very morning with multiple remands this morning that would have been the result of simply being on bail for something else and committing an offence that is really low-level offending, and how they come to the attention of the police. We would say that often is due to it's racist.
It's not an exceptional circumstance for us, it's every day.
Yeah.
Yes. And so in your recommendations on page 48, I'll just take you to a couple. Recommendation 41 provides that the government should increase understanding and application of Section 3A of the Bail Act by, and at subsection B, requiring all bail decision makers, judge magistrates, police and bail justices to complete mandatory and regular training on Section 3, capital A, cultural awareness, systemic racism and unconscious bias. Can we take it from that recommendation that you're of the view that there is a deficit in understanding of those particular aspects of the 3A inquiry?
Yes.
I've been very polite in the way I've put that, but...
Yes, and I mean, at the inquest into the death of Veronica Nelson led clear evidence that suggested that fact.
And recommendation 42, if I just draw you to the recommendation 42A,
yes.
It's recommended the Victorian Government should increase access to culturally appropriate bail hearings by expanding the jurisdiction of the Koori Court to include bail hearings.
Yes.
That would expand the work of the Koori Court significantly.
Yes, it would have resource implications that would have to be met.
And you're aware of that.
Yes.
But you say that it would have a significant impact on bail results for Aboriginal people?
Correct.
Thank you. Now, the next item I want to take you to in your submissions is that follows on from this section. It's at the bottom of page 48, and it's in relation to raising the age of minimum criminal responsibility. Mm-hmm. Your submission provides that it's Val's view that the minimum age of criminal responsibility should be at least 14 years and a minimum age of detention of 16 years.
Yes.
And is that position supported by any other agencies or international views?
Yes. It's supported by Smart Justice for Young People Coalition, which is a coalition of justice firms, so CLCs, Legal Aid Commission, also known as Victoria Legal Aid, social services bodies like Jesuit Social Services, the Victorian Aboriginal Childcare Agency, etc. We also have international support for this position, and in fact many other countries certainly would find our position unjust, that we currently can put a 10-year-old in prison. And
we see from your submission in the second paragraph on page 49 that the National Raise the Age campaign delivered a petition to the Federal Attorney General and Minister for Indigenous Affairs with over 200,000 signatures supporting the Raise the Age campaign, of which 65,800 were Victorian residents. That's a significant number of Victorians who support that particular reform.
It is, and also tangentially connected to that is the fact that prior to that, they completed a survey of the Australian community to see what they actually thought the criminal age of responsibility was. No surprises here, nobody thought it was 10.
So there's a plea to the Yoorrook Justice Commission at the last sentence of the second full paragraph on page 49, which reads, "We strongly encourage Yoorrook to take a strong stance on this issue. Raising the age must be on the government's agenda for the first 100 days after the election in November 2022. So by that submission, you're saying this needs immediate action.
Yes, I'm pleading, I'm begging, all of it.
And those submissions are made out in your recommendations on recommendation 44 to 46 on page 49.
Mm-hmm.
I just want to then take you to page 58 of your submissions, which deals with people in custody and under the heading Ending Violence in Custody. But one of the issues that is of particular importance is the healthcare that's provided to people in prison and youth detention.
Yes.
And can you just speak to the commissioners about Val's concerns in relation to this issue?
Gladly. Over the past 12 months in Victoria, there have been 3 Aboriginal deaths in custody, and the currently investigations into those deaths has revealed shocking evidence about the adequacy of healthcare provided in Victorian prisons. I'm not sure if you're aware, but prison healthcare is provided by a private body, Correct Care Australasia, and not through the Department of Health. And in fact, it's the Department of Justice and Community Safety that oversight that through their Justice Health section. Those 3 deaths are obviously reflective of a broader trend across Australia, with research from 2021 showing that Aboriginal people are 3 times more likely to not receive all required medical care before they die in custody. It's important to note that back in 1988, I think in Rickadick, when it first started, they investigated 99 deaths, 11 of which were women, and the vast majority, of course, of those deaths was lack of healthcare. So this is a trend that continues. There are some examples where healthcare is provided by outside health agencies. So in the ACT, Wongunga, which is an Aboriginal community-controlled health organisation, provide healthcare to the local prison there. And they do that through their doctors, their mental health nurses, their psychiatrists, psychologists, Aboriginal health workers, as well as also providing justice reinvestment programs and the like. And that obviously has led to improved health outcomes, but also provides a pathway for continuing healthcare once they exit prison, which is also very important. Certainly, what we're trying to push for here in Victoria is really addressing the challenges of the privatisation of healthcare, oversight of the delivery of healthcare through Department of Justice and Community Safety, which in our view should be through the Department of Health. Lack of independent oversight of prison healthcare, and people who are in prison actually can't access the Medicare benefit schedule or the pharmaceutical benefit scheme, which then affects what medications are available to them. And there's also a lack of culturally safe healthcare for Aboriginal people who are incarcerated. We're not alone on this position. VATCHO, which is the Victorian Aboriginal Community Controlled Health Organisation, as well as the ACTROs, have been clearing their demands for a culturally safe healthcare to be provided to Aboriginal people who are incarcerated for ACTROs. And I just wondered if you'd like to expand upon that, Sarah.
Sure, I guess I could speak to some specific. We speak to a lot of people in prison at VALS who have healthcare issues in custody. We speak to people who have to wait for weeks to see GPs, who have very, very serious medical issues, who come to us with issues like cancer and extremely serious medical ailments that are not being treated. We speak to people who have very serious mental health issues who are not provided with regular psychiatric support, but instead are often placed in solitary confinement to prevent their self-harm for extended periods of time as a mental health remedy rather than being provided with treatment. I think that there is, certainly from Val's view, and what we see in deaths in custody investigations, is that the impact of there being a private healthcare provider in Victoria's prisons is that there is a contractual incentive for that healthcare provider to avoid accountability for wrongdoing, for inadequate healthcare in custody as a first step, but also for deaths in custody. And there is a complete lack of oversight, from our view, on that private healthcare provider by Justice Health. The UN and the World Health Organisation say that healthcare in prisons should be provided by state services, the Department of Health. Yet in Victoria, not only is it overseen by the Justice Health Services, by the Justice Department, but then it's subcontracted out to a private provider, which leads to a complete fragmentation of healthcare and a complete lack of continuity of healthcare between the community and the prison setting. And with people moving between those two settings very frequently, particularly in Victoria, given our current bail laws, we see no continuity between those systems. And the Victorian government has said that there should be equivalent healthcare in prisons to that in the community. And we say that we can't see this at all. People in prisons, and particularly Aboriginal people in prisons, are treated, have received the impacts of racism in the healthcare that they receive in prisons, but also aren't provided with access to Aboriginal health services like VARs that are able to provide culturally safe healthcare, which they would have been provided with in the community.
And that access to healthcare is also predicated on the corrections officers themselves. And I've done a number of yarning circles this year at different prisons, and each and every time, numerous participants have talked about the fact that if they get into a dispute with a corrections officer, then their access to healthcare is hampered. And this is in the most dire of consequences. These are people, like Sarah said, who are suffering from cancer, from diabetes. And then there's also the problem that once they go through intake, a lot of the time they're not provided, particularly if they've got mental health issues, with those requisite medications. So they can go weeks, even months, as being reported, without that medication, which then can detrimentally affect their mental health and lead to really poor outcomes.
You probably don't know the answer to this, but it might be, is there any financial incentives within the contracts do they get paid more if they deliver less service, I guess, is my question.
Our understanding, I mean, we do know that the contracts are worth over $700 million between Correct Care Australasia and the Victorian government. That's over a number of years, not per year. From the publicly, there is a contract that is publicly available yet redacted. In that publicly available contract, there doesn't appear to be any financial incentives for the provision of good healthcare or inadequate healthcare. In our view, in any case, it would be impossible to tell because there is simply there doesn't appear to be any independent oversight of the healthcare that is provided to people in custody. And when there is a death in custody, those immediate first investigations which take place are done at the departmental level and internally within the prison healthcare provider. And so there is no independent oversight of the prison healthcare system.
And there's also no involvement of the family or any advocates in those reviews.
Is there access to the NDIS program for inmates in terms of disability supports?
I cannot give you a firm answer. Certainly my understanding from our clients is that there is a lack of access to disability supports.
I believe there's some access at some prisons to disability supports. What we hear from clients is that it might take many, many months or even years for them to get transferred to a part of the prison that has those disability supports available. So it differs prison by prison. NDIS is, people are meant to be able to get NDIS or sign up for NDIS at least in prison.
But the youth environments don't have those barriers in terms of requiring a transfer to an appropriate prison and then to an appropriate section. They're kind of better structured.
I just want to take you back, Ms. Waite, to the concern you raised about people having their medications or access to medical treatment withdrawn as a behavioural management tool. Are you aware of any formal complaints that have been made in respect of that type of conduct or behaviour?
Certainly in the yarning circles, they talked about that, they had tried to complain. So a lot of the time what they have is these little internal governance bodies that they can then communicate with the prison. So they'll use those as a way to communicate their complaints. But they report that when that happens, the record of what they report is incorrect, and often they face reprisal for making those complaints.
The withdrawal of medical treatment or access to medicines as a behavioural management response is quite a serious state of affairs. Wouldn't you agree?
But it's not behavioural management in the sense that it's just when they go into prison, they then have to submit a number of forms to then see a doctor or a psychiatrist, and those can take weeks to months, so they don't get access to their medications during that period. So it's less behavioural management and more poor intake. What happens is that where they have complained about health services or where they are trying to see a doctor, if they've had an issue with the corrections officer, then they'll find it difficult to lodge those necessary forms. They'll find it difficult to get access to those healthcare providers. They'll get difficult just even to get access to other services, which are few and far between during COVID and now the post-COVID environment.
Thank you for that clarification. I now want to take you to page 67 of your submissions, and you'll see, Commissioners, it goes over to page 68 and recommendations 81 onwards. At that page 67, your submissions speak to the need for independent review or investigation of Aboriginal deaths in custody. Can you just speak to the need for that particular response?
I think I've made this point before, but I'm happy to make it again. Aboriginal deaths in custody and police contact deaths inflict harm and trauma upon our communities. And when the people who are involved in that death are then investigating it, it is even harder for those families to trust the process, to engage, to feel like there will be true accountability and true justice. And it's also particularly harmful because often enough our communities have had, a history of really poor interaction and poor experiences with police and corrective environments. So then feeling as though with that history and with their involvement in a loved one's death, that there is an honest opportunity for truth to be told, it's rather limited. And there's a lack of independence when police investigate death in police custody or police contact death. There's, a nice word is deficient investigations, including a failure to preserve critical evidence, poor exercise of discretion regarding the investigation, and alarming lack of rigour. That obviously impacts the criminal process, but it also affects avenues for civil and criminal liability, and obviously limits that ability for truth and accountability as well. For us, racism, unconscious bias and lack of cultural competence within VicPol mean that families are not always treated with respect and dignity. And like I said, many Aboriginal people have a well-founded distrust in police. And whilst previous inquiries have recommended that the investigating coroner be given authority to direct the police investigation, there's actually not enough to meet those requirements. And whilst we celebrate the incredible work of the Career Engagement Unit and the adoption of the Indigenous Death in Custody practice note, which have improved some of the experiences and some of the issues, it just doesn't go far enough to ensure that independence and that ability to trust that there can be truth and accountability. And Sarah can expand on that further if you'd like.
I know that you had covered some of that earlier, and I thank you for that. If there's anything that you can add, Swartz?
I would just, I think Narita's covered it very well. I would just add that within the coronial process, we're talking about families who are experiencing extreme grief, the loss of a loved one. And when those families have to fight for fair investigations, to fight for evidence to be obtained, to fight for to be provided with evidence that hasn't been provided to them maybe for months or years, that can really exacerbate their grief and trauma. The Career Engagement Unit does an amazing job working with families, but the fact that we don't have an independent investigation in coronial proceedings, it exacerbates the grief and trauma of families, leads to distrust of the system. And we have situations where families, in many cases, are having to conduct their own investigations into their loved ones passing in custody, firstly because they're often not provided with any information for months after their loved one has died. They're left to speak to other people who are in prison with their loved one, other people in the community who have details. The department is sitting on swathes of information that's not provided early to families. And the fact that there's no time frame set also leads families to have to conduct their own investigations. And that process in and of itself further exacerbates trauma and grief, where I know in other jurisdictions families are provided with information at an early stage, sometimes a week after someone has died. I think that there could be provisions like that, but also fundamentally it's police investigating police that's leading to a huge amount of distrust.
So, given that it's police investigating police, families might already be suspicious, and where there is then extended delay in delivery of information, that only adds to that suspicion and their grief and trauma.
Yes. It feels like that death goes unacknowledged. It feels like that death doesn't have an impact. And it feels as though for community that every time a loved one comes into custody, you are preparing for that bad outcome because the same systems and issues repeat themselves over and over again.
A related issue I might seek your view on is whether a death in custody of an Aboriginal person has a much broader effect within their community and the Victorian Aboriginal community than, say, a non-Indigenous person's death in custody.
Yes. It's something that it affects families whenever a loved one goes in custody. Our CNS officers will often receive calls from families distraught and concerned and wanting welfare checks and wanting us to try and intervene with the prison to find out what is going on because they're so fearful that their loved one will become, Veronica Nelson, Heather Calgarrett, Josh Kerr. And then, there's the other effects of, looking at
Ms. Waite, we've been going for over 2 hours.
Yeah.
I've got about 10 or 15 minutes left in terms of the questions I need to ask. There's 2 more topics. Would you like a 5-minute break?
No, it's okay. We can proceed. I think it's just, it's a topic that hurts your spirit, and something for us that is an everyday reality. And we have to set up a unit, which is ridiculous, that we have to create specific units to deal with this issue because it is so prevalent. And, I see this commission Sorry, I've been talking about justice issues all week, and I think it feels all very overwhelming. I see this commission as an opportunity not only to transform the justice system, but to honour our communities, to honour our old people, and really make sure that, those ones who have lost their lives, that they get a chance to go home.
Thank you. I might ask a question now about those parts of the present system that require health responses as opposed to criminal justice responses.
Yes, that'd be great.
One of those areas which you speak to in your submissions is the reforms to the public drunkenness.
The long-awaited reforms. This was a reform that was put forward in Rickardick, which I think is older than me. It wasn't implemented in Victoria. We then had the death of Auntie Tanya Day, who was arrested on a train for sleeping, really. And as a result of that inquest and the coroner's early recommendations that the public intoxication laws be revoked, the Victorian government committed to do so. It's important to note that they missed their deadline and they had to seek an extension. And that reform has again been complicated by issues relating to structural racism, but also, the roles of the law and order narrative, the police union's involvement, and also that age-old issue of resources.
But it is the case that the public drunkenness reforms are really minor reforms in the scheme of things that shouldn't attract this level of opposition.
No, not at all.
You've set out some reasons just now as to why that hasn't happened, but it speaks volumes as to the difficulty in terms of reform that runs against the law and order narrative. Is that correct?
Yes, it's an inability to see what are health issues as health issues, and instead implement a justice response because that's our default to ensuring community safety. It is really frustrating, particularly in this space, because these reforms are well overdue, and there has been much work about it, but often the narrative is boiled down to, drunk people are problems because they're going to act aggressively, they're going to hurt people. There's this assumption that if you're intoxicated, you will do harm. And it is frustrating, and often enough that is levied at the Aboriginal community in particular. Even in resourcing the trials, there was all this money committed to mainstream trials and getting them set up, but we had to fight hard and really hard to get resources for a standalone Aboriginal response. But yet, our services, particularly our ACHOs, had already been delivering these services in the past, but had been cut off in terms of sobering centres, in terms of what we call crew night patrols. But again, we were just to tick the box, an afterthought. And, you know, Victoria Police have been on notice that this is a reform that is going in place, but in regional communities like Mildura, you're seeing 100% uptake in people being charged with, you know, public drunkenness in the last year. I mean, it's horrifying.
Those figures would indicate a disconnect between policing practices in Mildura and the current sentiment in regards to dealing with drunkenness as a health issue.
Correct, and it underlies our concern that unless there is proper implementation and oversight of police, what you will see is where they don't have the power to arrest an Aboriginal person for being publicly intoxicated, they'll use other powers to arrest and detain, and that Aboriginal person will end up in a cell in a very vulnerable position.
Thank you. You also mentioned in your submissions the decriminalisation of drug possession for personal use, and you're aware of the recommendations coming from the ICE inquiry in New South Wales regarding a health response to personal drug use and addiction?
Yes, certainly some of that early work helped inform our policy paper entitled Harm Reduction on Harm Maximisation and Alternative Approach to Drug Possession.
And you also speak to health-based responses to mental health and disability.
Yes.
It's another area in which health response is required rather than a criminal law response.
Yes. And at the moment, those justice responses in those circumstances can have a really disastrous impact. And I wonder if we would have a quick moment just to take you through an example, particularly in the mental health space.
I'm in the Commissioner's hands. I'm comfortable with a further example.
Thank you, I appreciate it. Want to talk to that example?
Sure. So, young Aboriginal man, early 30s, no prior interaction with police.
What man, sorry?
Oh, sorry. Young Aboriginal man, early
Aboriginal
30s.
Man,
no previous interactions with police, no criminal cries whatsoever. Behaving erratically in a park. Police are called. They speak to this young man. They search him. It quickly escalates into an arrest because they find a small amount of drugs on him. Police concede that it's small and personal use. There's no other, he's posing no threat to the community. This is also conceded by police. The behaviour is non-threatening. He's arrested, taken to a police station, interviewed and released on bail. A couple of weeks later, similar situation. This time the young man's on the street, again having what the police concede to be obviously a mental health crisis. Again, search the young man. Again, find a small amount of personal use drugs. He's arrested, taken to a police station, interviewed, released on bail again. Now, this happened pre-bail, the bail reforms. Had this happened now and he picked up a third time, he would then find himself with a presumption against his bail, and in court he'd need to demonstrate exceptional circumstances to be granted bail. The biggest problem is, of course, that his mental health issues and his drug issues now being dealt in the criminal justice system. So when it finally is resolved in the court system, the only people that have any real input into this young man's fate is a lawyer, a police prosecutor and a magistrate, an ex-lawyer. At no point in this at the table is a health professional engaged, is a health professional's opinion sought. One, because, of course, we wouldn't get funding for a medical report for such low-level offending. And it's a matter that obviously this young man wants to deal with very quickly, doesn't want to spend any more time in court than he has to, but now he's entangled in the criminal justice system. And otherwise, to all other appearances, a member of society, a fine, functioning member of the community that actually just required help with his mental health issues. So that's one very clear example of police intervention really being a detriment to this young man's life. And now he's got a court outcome, among other things. And it's problematic for him, along with just, you know, the other racist, the other systemic racism that happens. Him just gaining employment, now loaded up with a criminal record. It's a significant problem. For otherwise, the contact police just by result of him having a mental health crisis.
Mm. And I think the earlier case example where we went through M also talked to why police shouldn't be involved in mental health responses. And certainly it's so widespread. I mean, it was really tragic to hear a few months back at a forum a mother raise her concern about the way her daughter, who was fleeing sexual assault and experiencing a mental health episode associated with that, was tasered and then suffered a head injury and then continued to be tasered even though she was unconscious, which had now escalated a mental health issue, instituted a fear of engaging with police, and ultimately meant that, you know, she didn't pursue the wrongs committed against her. So it plays out in all different ways, and there are such high rates of mental health and disability amongst our communities. I think the last estimates were that those who are our imprisoned community members, they're facing like rates of 85% in terms of mental health and disability. A lot of the time, our children who come to our attention in the criminal field will have diagnosed mental health conditions associated with their removal as a child, and resulting inconsistency and being connected to culture, kin and community, and also just really harsh residential care environments.
Thank you. Did I hear the figure correct? Did you say up to 35%?
No, I believe the last report was around 85%.
85%?
Yes.
Of people in custody have?
Aboriginal people in custody. Yes. Yeah, but I can't for certain say that. I don't know if it was 85 or 87.
Thank you.
I believe that to be well understood and accepted.
Yes.
That's the fact.
Yeah, and I mean, the sad thing is it could even be higher because there isn't appropriate screening for disability and mental health within these environments. And particularly when we're looking at how often Aboriginal people who won't serve custodial sentences cycle through the remand cycle, I mean, those issues are never going to be picked up for them, so they won't account in those statistics. But, when we certainly do intake with them, those issues that they identify themselves as requiring supports, but when you don't have a roof over your head, when you don't have any stability, and when you're constantly being over-policed and criminalised, I mean, when do you have time to get the help for those substantive issues?
Thank you.
And it's also the case that a significant proportion of them have cognitive disabilities, not amounting to mental illness as such.
Yes.
But a cognitive impairment of one way or the other.
Yes.
A significant proportion have both.
It's horrifying. And there's even not appropriate supports in place for those, because even when they're trying to undertake programs that they're required to in order to obtain parole where they're sentenced, or even if they're just trying to do programs to keep themselves occupied, there aren't programs that are tailored to those with cognitive disabilities or any form of disability. So then how can they adequately address their risk or be seen to engaging in supports if those supports are not suitable for them? Sorry, I think I've taken us somewhere else.
I'm very happy to be taken in that direction. One of the additional matters that you've addressed in your submissions is the need for some reform in respect of parole matters. And in particular, on page 63, sorry, Commissioners, 63, recommendation 71, one of the recommendations is that at recommendation 71F, that youth and adult parole boards exemptions from the operation of the Victorian Charter on Human Rights and Responsibilities should be removed.
Yes.
There are a number of reforms you're recommending with respect to the parole boards. Is it the case that there might be application of the Charter of Human Rights in that parole setting for decisions that are made?
Sorry, are you asking if...
I didn't get that either.
Sorry.
So you mean hypothetically it could be so? Or
If the exemptions for parole are removed from the Charter, would there be circumstances in which VALs could see applications being made or complaints being made under the Charter?
Well, it would be a public authority under the Charter.
Exactly, yeah. So then
it would be applicable according to its terms. The exemption takes it out of that range.
Yes, and so
it would be it would be automatic. It would be a public authority, and the consequences under the Charter would flow, I would expect.
Yes, I agree with your assessment.
I accept that point, Commissioner Bell.
Yes.
The point is, are there circumstances which would be otherwise then be breaches of the Charter? And I see Ms. Schwartz nodding her head.
Yeah, I mean, I'm thinking with the...
I'm just nodding my head because I think that, we're obviously not appearing before the parole board because we can't, because there's no procedural fairness in front of the parole or natural justice. So I think as a first step, there'd be an automatic breach in that people aren't being provided with legal representation or procedural fairness, which means that even if we are representing someone, which we do occasionally, for example, kids who are transferred by the youth parole board to the adult prison system, or by the adult parole board aren't transferred back to the youth justice system. We're not even given access to any documents or anything. So, as a very first step, yes.
I think, Council, your question really is: are there human rights in the Charter to which the parole board would have to have regard?
That's another way of putting it, yes. Commissioner Bell.
Yes.
Thank you.
Can you answer that question, maybe? Are there human rights in the Charter to which the parole board would have to have regard?
Yes.
Yes.
I note the other recommendations with respect to the amendments to the Corrections Act, the CYFA and the Youth Justice Act, which are contained in recommendation 71.
Mm-hmm.
I won't take you to each of those now. They're in the submissions. You have. I will take you to one other issue. Recommended that there be an Aboriginal Social Justice Commissioner appointed to oversight Aboriginal justice issues.
Yep.
Can you just speak to that recommendation?
Sure. So this recommendation is actually originally a recommendation from the Aboriginal Justice Caucus, from the Aboriginal Justice Agreement. And this recommendation arises from a long-held frustration that there has been no oversight and implementation of a number of inquiries relating to Aboriginal people, obviously including Rigadik, but also that when there is a death in custody, that there is no capacity to participate in those immediate reviews done by Justice Health and what was then JARO, but I believe is now iterating into something else.
Thank you.
And they would also obviously provide advocacy and advice on justice issues relating to Aboriginal people, but also that role that we talked about earlier around Aboriginal impact statements.
There is one further area I wish to touch on, and that is in relation to sentencing reform, and in particular the use of Aboriginal community justice reports.
Yes.
Could you just explain what Aboriginal community justice reports are for the Commissioners?
Yes. Sorry, it's one of my favourite programs. So we currently run a pilot called Aboriginal Community Justice Reports. and that report operates from a strengths-based perspective and is supposed to inform sentencing. At the moment, it's piloted in the County Court of Victoria in Latrobe and Melbourne, across both mainstream and Koori Court, and the court has had really positive feedback. They've engaged in continual training, and there is a desire to rapidly expand it, but at the moment it's literally self-funded, so that's just not possible. But it has had some really good outcomes, not only just in terms of having that the psychiatrist input as well as obviously the cultural input, but really allowing somebody to tell their story, not just about themselves but about their family, and really that intergenerational trauma and impact, and then really look for ways that they think can not solve these issues but help them along their way to healing, and also how they can engage in restorative practice. How do they engage in righting their wrongs? And we've had positive reports from participants. We've never had anybody withdraw as yet. We've seen some favourable commentary in Supreme Court judgment. So it's wonderful, and it's something that should be expanded further, and was based on good due reporting from Canada, which is now widespread and has evidence of being really impactful.
Did VALS initiate this program?
Yeah, so it was developed and initiated over a partnership with our Canadian ALS counterpart. So we engaged in a number of study swaps. So they went over there, we came over, kind of did little swaps to see how it could operate. We then developed the project. We went through an ARC bid process. It took a few tries, but we got there. And that has allowed the evaluation to continue, which is currently being done by Thalia Anthony at UTS.
And are those reports prepared by VALS of its own volition, or are they court-ordered reports?
No. So the individual is the one who has to request them. They can do that through their lawyer representative. The representative does not have to be from VALS. It can be from VLA, it can be from a private law firm, CLC, wherever. We're not fussed. And then we then work with that client. And it's not just one meeting, it's a series of meetings in yarns, just noting that there is a lot of trauma and I suppose just it is quite difficult for them to engage in such a thorough process. They then review that report with their lawyer, and then it's then submitted to the court. At the moment, it's mostly used in the Koori Court setting.
And the funding for that program?
So the ARC funding principally supports the UTS evaluation function, which is really important then to developing a further bid for funding. And then there is a little funding to support the development of those reports, which was supposed to be just 12 reports. We've certainly surpassed that, and now it's basically just self-funded.
But it's a matter which the reports are reports that have been well received by the courts?
Yes, and the reports are also a recommendation of Phase 4 of the Aboriginal Justice Agreement.
VALS would say, I suspect, that it's a matter for which it ought to be funded to deliver in a more widespread fashion.
Yes, certainly across the state and also across the Magistrates Court, just noting that when looking at the breakdown of matters across both courts, it's important we have that magistrate coverage given a lot of our matters are there.
Thank you very much. I was glad that we could end on a high point. It's been a long trip this afternoon. Thank you very much for staying with us. They're the questions I have in Chief, Commissioners.
No, I'm right.
No, I've asked my questions as we've gone along. Thank you.
I've just got one topic to cover, and I'll try and keep it brief, and it relates to the question of public confidence in the current system for investigating police complaints.
Yes.
And particularly confidence by Val's in the current system or lacking that confidence. You've called for the establishment of an independent, fully independent system for complete police complaints. Can you tell the Commission whether you have confidence in the present system or not?
No confidence whatsoever.
And could you just briefly explain why it is that you lack that confidence?
Sure. So a lot of it, we've been calling for independent police oversight for quite some time, and it's been a long-standing piece of advocacy work for us. And through that, we've been able to look at models like in Northern Ireland, which have been incredibly impactful in increasing community confidence in police, but also ensuring that there is an independent investigation. And the reason why we want to implement a similar model here is because at the moment, Aboriginal people are entirely distrustful of making complaints about police because they just go back to police for investigation. It's a direct conflict of interest. It makes no sense. And often enough, particularly in regional Victoria, it's even more precarious to make those complaints because often enough you can find the same police station investigating the complaint of which the officer was from.
Thank you. Now, I think it was you, Ms. Waite, before that drew a connection between the need for independent and effective investigation of police complaints and the operation of the criminal justice system generally. The point was made that the two are connected. Can you explain that connection, please?
So just so I can
I think the idea was that without an effective and independent investigation system for complaints against police, the whole system is undermined.
Well, yeah, I mean, for me, police accountability is part of creating a justice system. If we can't have an independent police oversight system, how can we ensure that over-policing doesn't occur? How can we ensure that systemic racism is addressed? All of these key issues for us, so that situations like M don't occur, where we're talking 90 plus charges for matters that should never have come to their attention, they never should have dealt with.
Thank you.
For me, that's why.
Thank you.
Thank you, Commissioners. Commissioners, I tendered the submission from the Victorian Aboriginal Legal Service in relation to child protection, dated November 2022, and that's document 7.6.1 and document 7.6.2, which is the submission of the Victorian Aboriginal Legal Service criminal legal system. And I take a moment before sitting down to draw the Commission's attention to page 73 of that submission, 74, where it appears that the many submissions, letters, policy papers and webinars and podcasts and community fact sheets and petitions of the prepared by the Victorian Aboriginal Legal Service are set out, and it appears that they're hyperlinked and will form part of the submission. And I also draw your attention to Annexure B, which is at page 75, which sets out the witnesses that the Yoorrook Justice Commission should invite or compel to give evidence, including the Premier, current and former Attorney Generals, Minister for Police, current and former Ministers for Correction, Minister for Youth Justice, current and former Ministers for Aboriginal Affairs, Minister for Health, Minister for Mental Health, and various officers from Victoria Police, TPAV, IBAC, Corrections, Correct Care Australasia, G45 Correctional Services, St Vincent's Correctional Health Services, Forensic Care, DJCS, the Adult Parole Board, Youth Parole Board, the Judiciary, Court Services Victoria, and the Office of the Victorian Ombudsman, and the Commissioner for Children, Youth and Young Children and Young People, and that's page 75 to 76. And I note that the submissions from the Victorian Aboriginal Legal Service include a recommendation that the term of this commission be extended in order to have time to hear those witnesses.
Yes, please.
Thank you.
Thank you, Commissioners.
Noted, and they will be added to the next exhibit numbers. Thank you, Council. Thank you all very much. So, concludes our session for today.
It does, Commissioner, and we have further witnesses tomorrow.
We'll resume at 10 a.m. in the morning.